Yes.
To mention, my lord, for inclusion in the list, my lord, some motion matters and one hearing.
Some motions.
My lord, two motions.
Motions.
And two of
Why not in singular?
my lord,
And
and one hearing.
hearing it will appear, because I tell you why. But today you will find, tomorrow, yesterday I have almost done with 30 hearing matters. Nobody appeared. 3 appeared, I disposed of by dictating judgment here and now in the court itself. Now then I said that every day 50 hearing matters will be in list. So if today I dealt with 15, then another 15 will be added. So 35 plus 15. But yesterday, somehow the officer was not available, so it could not be done. From today, it will be done.
Lordship.
If I dispose of 10 today or adjourn 10 today, 10 fresh will be added tomorrow. So don't worry for that.
My lord, then motion matters.
Motions, yes.
Lordship, I have the similar one.
1 second. Motion, give notice, come tomorrow.
Lordship.
Affidavit of service.
Lordship.
1 second. Motion. 1 second. Huh? Calcutta.
Lordship.
1 second.
New motion.
Same,
It is done.
আচ্ছা এটা না ভাগ করে দিন, ওরকম ভাবে রাখবেন না। আপনি যে কটা জমবে, শুনুন যে কটা মোশন পড়বে পরে আর স্লিপ নেবেন না কেউ দিতে এলে। এখন মেনশনিং স্টেজে স্লিপ নিন। মোশনের যে কটা জমবে, যদি 15টার মধ্যে হয় তাহলে কালকে 15টা দেবেন, যদি 30টা হয় তাহলে 15 করে কাল পরশু ভাগ করে দেবেন।
Hello.
Only motion. And don't give any sleep of hearing that let it appear under the motion. We will see then. Don't do that. If I find that,
Hello.
then it will be adjourned for 6 months.
Hello.
Then
Hello.
I will adjourn those 6 months, because I believe in harmony and I believe in the mutual understanding between bar and the bench. So give real motions, it will appear. But under the guise of motion, if somebody gives hearing and I find it that the sleep was given and it appears, I will simply, sir, adjourn for 6 months, at least. Simply adjourn for 6 months. Yeah. Don't do that. Give real motions, it will appear.
My lord, this is a contempt matter. Your lordship will remember this matter was taken up before the principal bench on the
Very well.
next Friday.
Friday.
My lord.
Contempt of Friday লিখে দিন।
Lordship, may I be mentioned?
In those matters where affidavits are directed but not filed, don't treat them as motion and don't give the slip. Motion means only motion, where affidavit has not been directed. If I find one single such, I will serve then adjourn, madam, for 6 months.
Lordship, may I?
Yes.
I'm asking myself, under which heading that matters will appear?
Which one, madam?
The
After affidavit?
No,
What?
affidavit not submitted. by the
Doesn't
state.
matter. It will appear under the hearing. It will have to appear under the hearing. Previously, in the rules, in the original side rules, there is a provision unopposed. But that practice is gone. In the appellate side also, there are provisions unopposed, but that practice is gone. So it will have to appear under for hearing.
Lordship, may I permit you to mention two matters, Lordship? In one matter,
Mike,
in one matter, there is a direction for the filing opposition, Lordship.
so don't mention that.
No, Lordship, the preemptory direction was in the month of the September, Lordship. Till now, they have not, I have already.
Madam, don't mention. It will appear under the heading hearing.
Yes.
Let the list go on then.
And Lordship, in one matter, there is a liberty to mention before next circuit, Lordship. So next.
Hearing matter.
Yes, in this matter also, there is a direction for the filing of opposition. Till now, we have not received.
But it will have liberty to mention, very well give it appear for hearing.
Yes.
For hearing লিখে দিন। মাথার উপর for hearing লিখে দিন।
Lordship, same here, Lordship, hearing matters. Let
Well,
the matter
was
be-
there any liberty to mention?
Lordship,
Liberty to mention? Don't do that.
To mention, no.
Milord, may I permit to mention one application, Milord? The application for appropriate order, but their last.
And do one thing. Better ঠিক আছে শুনুন একটা কাজ করাই। Hearing matters. Any one of you take charge, collect the slips. collect the slips, give it to my officer. She will consult me. I will direct them to appear one by one. Any one of your, any learned member take the charge, collect the slip, staple it, give it to my officer for hearing, only for hearing.
My lord, may I permit to mention one application, my lord, for appropriate order, my lord?
What appropriate order? Disposal of the writ
No,
petition.
no, this is pending matter. Last occasion, there is a direction to deposit the money to the learned register.
আচ্ছা, very well.
Till now, the
Application heading এ দিয়ে দিন, পরশু দিয়ে দিন।
Milord, may I have your lordship kind leave to mention a matter for inclusion in the list? These are 27 land acquisition matter. The matter was
27
land ac-
numbers.
Yes, Milord. Land acquisition matters came up for before Justice Hiranmay Bhattacharya. Justice Hiranmay Bhattacharya directed to submit a report for state. Kindly have a look at the order, Milord.
No, then what happened?
Milord, till date no report has been submitted.
So hearing, it will give, appear under the heading hearing. Give.
Milord, and one application for recalling of your lord.
এটা আপনি এই hearing না, hearing you give slip to somebody. I've just directed, one of your learned friend must be collecting the slips. Give it to.
And one application and one motion, Milord.
Application for what?
Application for recalling of your lordship's order, Milord.
My order.
Yes, Milord.
Application heading এ দিয়ে দিন,
Milord, and one motion, Milord.
কালকে দিয়ে দিন application. Motion,
Motion.
sub notice
Milord.
দিয়ে দিন কালকে. But unless respondents are there and you don't file affidavit of service, I will not take up.
Milord, first time it is appearing, Milord.
So what? You have
Milord,
to
I shall
serve.
file my affidavit of service.
Ah.
I shall file. Milord, and one more, Milord, contempt of justice, Abhijit Gangopathyay's order, Milord.
Contempt.
Contempt application, Milord. Justice
How
Gangopathyay.
can I take up? Unless it is, there are benches.
Milord, I know, Milord, but
No,
order was
I will
passed.
not take up. Because there are benches where you have to move that learned judge who is not available. I cannot take up.
My lord, may I permit to mention one matter for inclusion for restoration, my lord?
Restoration.
Restoration.
কালকে দিয়ে দিন application কালকে। আর hearing এর যে লিস্টটা না দিদি, hearing এর লিস্টটা ম্যাডাম you are collecting?
Yes.
Very well. Hearing এর লিস্টটা একটা স্টেপল করে ওরা দেবে, সেটা আমার সঙ্গে দেখাবেন, আমরা আগে স্প্লিট করবো তারপর।
My lord, may I be permitted to mention one matter for inclusion in the list?
Motion or hearing?
Motion.
Motion. Tomorrow দিয়ে দিন। আচ্ছা শুনুন, কিভাবে করবেন শুনুন, কালকে যেগুলো অ্যাপিয়ার করতে বলছি, ধরুন আজকের লিস্ট থেকে 6টা মোশন রয়ে গেল, তাহলে ওই 6টা আগে আসবে। স্যার 1 সেকেন্ড স্যার, ওই 6টা আগে আসবে, তারপরে এইগুলো। ইয়েস মিস্টার মজুমদার।
Repeat, the matter right now mentioned before my lord. has-
স্যার 1 সেকেন্ড, আপনি আমার কাছে আসবেন, আমি কথা বলে নেব।
My lord,
yes.
That is not a motion matter. It is
Which
long
one?
pending matter. Right now it was mentioned.
No, nothing has been mentioned. Who mentioned?
It is not a motion matter, my lord. It is long pending.
কি হয়েছে? কি হয়েছে?
লাস্ট অর্ডার আছে দেখুন, লাস্ট অর্ডার আছে।
Lordship, there was a,
আমি
his
2001
allegation is that matter. His allegation is that he had taken loan or no loan. Certain men holding out themselves to be bank officers came and seized his property. Alleged to be under the bank, ART order. He had come up before the court for a CBI inquiry. CBI inquired and filed 2 reports. CBI has also filed a closure report before the jurisdictional court. But since the writ is pending before my lord, the closure report could not be accepted. So it is going on and on and on. Every time the prayer before this court is being made, we do not know what the CBI is supposed to do. CBI has inquired, filed a report that nothing wrong has been found. And we have also filed documents showing what happened. So my lord, this is a purely hearing matter. If your lordship is in a position to take up hearing matters.
You mentioned before the next circuit, because I have already taken up hearing matters.
হুজুর, আমি 2001 সাল থেকে একটা ব্যাংক আমার কাছে 1 টাকা পাবে না, মোর দেন 100 কোটি টাকার উপর সম্পত্তি বিক্রি করে দিয়েছে। কন্টিনিউ কোর্টকে 2001 সাল থেকে এখন অব্দি কোর্টকে মিসলিড করে যাচ্ছে। আমার কি বিচার করার কোনো অধিকারই নেই?
কি করবে?
প্রত্যেকটা সার্কিটে মেনশন করতে আসি, প্রত্যেকটা সার্কিটে মেনশনিং নেক্সট আমি একটা লোক খেতে পাচ্ছি না, চলতে পাচ্ছি না, প্রত্যেকটা দিন আমার কোর্টে যেতে হচ্ছে, সিবিআই জাল কাগজপত্র কোর্টে জমা দিচ্ছে, তার বিচার হবে না?
কি হয়েছে?
এটা তো সভ্যতার বিচার ব্যবস্থা হতে পারে না।
On the last occasion when your lordship was here, you directed the bank to file a report, the reconciliation statement. We have filed the report, and then in the report it says that, and after selling the property, what was the residue? The residue matter has been given back to you.
Oh, residual
Yes,
amount has
yes,
been
the-
given.
the-
জামা
But
কাপড়
certain substance
এভরিথিং,
is a decision of the bank. taken
ইভেন আমার
upon him.
স্টাফের জামা
The
কাপড়
remedy rises
এভরিথিং।
in the
ঠিক আছে,
DRT.
এটা অ্যাপিয়ার করিয়ে দিন হিয়ারিং লিস্টে। এদিকে শুনুন দিদি, ওটাকে 10 তারিখে অ্যাপিয়ার করিয়ে দিন হিয়ারিং লিস্টে।
That-
May I be permitted?
শুনুন, yes,
May I be permitted to allow, my lord, it's a matter of motion stage. It pertains to illegal detention of accused person who are an Iranian refugee. She is seeking asylum in India. The case was started against him on 22.
what you are on?
I'm in custody. Illegal detention. So report has been called from IC Kotwali. The case was started 22nd February 2024. So it's motion stage. So okay,
Motion stage.
motion stage, my lord.
Affidavits are,
Report has been covered, how it can be in the motion stage? And without issuing notice, this has been mentioned. Notice has been called for.
you mention in the next week.
But a state appeared, then how it is in motion? The report has been called for. It is acted on motion.
You mention in the next week, next.
Lordship,
Yes,
may I be permitted to make one mention, your Lordship?
yes,
Lordship, I am praying for inclusion of one read matter for the which is under in the hearing stage. Affidavit has already been exchanged.
hearing.
Yes, your Lordship, it is in
You
the
ask
in
your,
the
you
hearing
ask
stage.
your person who is present here to give the slip. Hearing slip has
Lordship,
been
he has
collected.
Lordship, he has already given the slip, but inadvertently he has given the slip to the bench clerk, your Lordship.
Yes,
May it
bench,
be
I have
given-
directed that. Today I have directed that. To give the slips to one of your learned friend who has collected all the hearing slips, she will deliver and hand over to my officer.
No, Lordship, he inadvertently he deposited to the bench clerk instead of giving it to my learned friend, whom your Lordship have directed.
Very well,
Lordship,
it will be seen, don't worry. Next.
Lordship, I'm deeply
যা slip
obliged.
থাকবে না, যা slip থাকবে একবার নিয়ে আসবেন তো বিকেলে। কথা বলুন। Next. Yes, call the list.
Yeah, deeply obliged. Your Lordship.
Why to be mentioned?
Lordship, the content application has been, the order has been complied, your Lordship. We withdraw the contempt application.
Content cannot be withdrawn. Next, is it compliant?
Yes, your Lordship.
You are for the petitioner.
Petitioner, your Lordship.
Show me the compliance. Who is for the alleged contempt, sir? Compliant.
Lordship, if your Lordship is kind enough to recall,
Don't.
a direction was passed by your Lordship. LP3
Compliant.
Yeah.
You say compliant, sir.
Right.
Matter
But
ends.
against our order, they have again filed another writ.
That is a different issue. Let them
We have
do.
complied.
That is more the merrier for the profession. Always welcome. এটা কি?
Page 3, your Lordship.
You are for the petitioner.
Yes, your Lordship.
Where is the compliance report?
Your Lordship.
Have you filed any compliance reports, Mr. Additional Solicitor?
Lordship, actually, my lord had directed that a hearing be done after giving them an opportunity to appear. So hearing was done, after giving them an opportunity, they were there, they were heard.
Reasoned order passed.
Reasoned order was passed.
Reasoned order passed. Give a copy of this reasoned order. I will keep it on record.
That is, your Lordship.
Huh?
I will submit, your Lordship.
You will not do. You now do it.
May he present the case?
I hand it over, your Lordship.
So I'm keeping it in the
Lordship.
record. That's all. Ashu. This is a content proceeding arising from an order dated April 5, 2023, passed by this court. Poster. Today, paragraph. What's your name, sir?
Alok Shah. Alok Shah.
Alok?
Shah. Yes, H.
Today, Mr. Alok Shah, learned counsel appears for the petitioner submits, appearing for the petitioner submits that the direction and order of this court stands complied with by the alleged contender. How many contender?
One, Your Lordship.
By the alleged contender. Alleged contender. The reasoned order dated November 6, 2023. Showing compliance of the direction of this court placed before this court is taken on record. Paragraph. Mr. Sudipto Mojumdar. Sudipto Kumar?
Kumar, Your Lordship.
Sudipto Kumar Mojumdar.
Kumar adds a little, cuts down the age.
Still now you are Kumar.
I like to be my lord.
Then of course,
In
appreciable.
Factually not my lord.
Appreciable. Mr. Sudipto Kumar Mojumdar, learned
DSGI.
Deputy
Deputy Solicitor.
learned Deputy Solicitor General, appearing for the alleged contender, has also confirmed this court that the direction of the court stands compliant. Paragraph. In view of the above, nothing further survives in the content proceeding. Paragraph. Accordingly, this content proceeding CPAN, bold, huh? CPAN, bold kintu, 68 of 2023 stands stopped and closed. Poster. Paragraph. The application CPAN 68 of 2023 accordingly stands disposed of. Thank you. এটা রেকর্ডে দেখে দেবেন, ফেরত দেবেন না। Next.
My lordship, kindly see the order last passed on 13th of March 2024. But there is a direction to file affidavit in opposition.
13th.
13th of March, the last order, 13th of March 2024. Lordship kindly comes to the last 3 paragraphs of the order.
Yes, read it.
My lord, the factual dispute which has cropped up on the filing of supplementary affidavit needs to be resolved to decide the legality and propriety of the order impugned. Therefore, the respondents are directed to affirm affidavit in opposition to the supplementary affidavit within a week from date. Reply thereto, if any.
All right,
be
hold on.
affirmed.
Next.
Thereafter, matter be listed in the available circuit bench after expiry of the above mentioned period. There shall be the stay of operation of the order impugned for the period of 3 weeks from the date or until further order, whichever is earlier. Now, my lord, opposition has not been filed. Now, my lord, the interim order is expiring tomorrow, my lord. So, my lord, I am praying for.
We have to find.
All right.
After serving this order has been passed.
All right. Ashok.
And my lord,
MS.
one more thing, my lord. My lord, the next circuit is starting from 13th of May, lordship.
No.
Yes,
No,
yes.
no, no.
Partial modification. My lord, I have got my partial modification.
No, it is 3rd May.
No,
3rd
my
May.
lord. 13th May, my lord.
ঠিক আছে বাবা, চলো।
হ্যাঁ, বলছে, এসছে।
All right, doesn't matter. আসো। আমিও দেখিনি, খেয়াল করবো। আচ্ছা,
Madam,
next
may-
class. You are saying, madam, what more?
My lord, extremely great.
This harmony, if is not there, then how the system will act?
My lord,
কি
extend.
বললাম লিখুন today the writ petition has appeared under the heading quote unquote extension of interim order. Poster. MS
Shumon Jain.
Suman Shehanabish, bracket Mundul. Learned counsel appears for the petitioner. Paragraph. Mr. Manirul Muminul Islam. Rahman. Why I am forgetting immediately? Mr. Momin, no. Aging. Mr. Mominul Rahman, Landed State Council,
But I'm for the private respondent.
pays for an extension of time to file affidavit in opposition to the supplementary affidavit.
But I am also praying for extension.
Paragraph. Mr. Vikramaditya Ghosh
Now, Millard's memory is right.
from the order sheet. Mr. Vikramaditya Ghosh, Learned Counsel appearing for respondent number 8 and 9. Also seeks an extension for filing affidavit in opposition. Identical extension. Seeks an identical extension. তাহলে অত বলতে হবে না. Full stop. Paragraph. For the ends of justice, time to file affidavit in opposition stands extended till
By a fortnight.
give me a date. Give
Give
me a date. I don't mind. You give me a date. আজকে কত তারিখ?
30th
April 30, 2024. Paragraph. Reply, comma, if any, thereto shall be filed by
1 week thereafter.
10th May, May 10, 2024. Paragraph. Parties shall be at liberty to mention the writ petition for inclusion in the list of hearing before the next available circuit bench then, comma, subject to its convenience, comma, upon notice to each other. Paragraph. The interim order passed on March 13, 2024 stands extended till June 30, 2024 or until further order, whichever is earlier.
Extremely grateful.
Lordship, I'm led by Mr. Arjun Chaudhary. I'm paying for short pass over Lordship. Lordship, kindly, Lordship.
What is this application for?
Lordship,
Lordship, it is an application for drawing up why a contempt proceeding should not be drawn up against the respondents as they could not comply with the court's direction to file.
It is a content.
No, Lordship. It is a can with the prayer is that.
Digi.
Anyhow, my lord, the thing is this, I represent respondent number 1. I was supposed to file a report.
Just let me see.
Yes, madam.
Affidavit in opposition filed?
No, your lordships, we need 7 days more time. Your lordship. It's already ready, but not affirmed.
Oh, since you have not filed affidavit, that's why
That's why
contempt. Excellent.
An application.
Fine.
Ash,
Lordship, kindly
Lordship.
short pass over, Lordship.
this is an application
Lordship.
taken out by the writ petitioner. Paragraph. What's your name, madam?
Riya Agarwal. Riya Agarwal.
MS
Lordship.
Riya Agarwal, learned counsel, advocate appears for the petitioner. Paragraph. Mr. Shudipto Kumar Mojumdar, learned deputy solicitor general, appears for
Respondent number 1.
respondent number 1.
And your lordships 2 and
Paragraph. Mr.
Ajay Kumar Singhania.
Ajay Kumar Singhania, learned counsel, appears for respondent number
234. 234.
2224. 224. Huh? Paragraph. The prayers in the said application, the prayers made in the said application, the prayer made in the said application is set out below. Set out one. ঠিক আছে একটাই set out থাকে set out. ঠিক আছে বাসু
Well, how for the
full
petition?
stop. Paragraph. On perusal of the orders dated November 29, 2023 and January 5, 2024. Annexed to the said appended to the said application, it appears to this court that 7 accept directions for filing affidavits. There was no other direction
My lord, may I say one thing? My lord?
which can be said to have been not complied with by the respondents. However, there is no contempt application taken out in any event. However, there is no contempt application has been taken out. Full stop. Paragraph. Today, both the learned counsel appearing for the respondents seek extension of time. Seek na kore pray for extension of time to file their respective affidavits in opposition. For the ends of justice, such prayer is allowed. Full stop. Paragraph. The affidavit in opposition. Time to file affidavit in opposition stands extended parenterally till April 24, 2024. Paragraph. Affidavit in reply, comma, if any, comma, thereto shall be filed by May 15, 2024. Paragraph. After completion of the aforesaid period, the parties shall be at liberty to mention the writ petition to appear under the heading for hearing before the next available circuit bench then, comma, subject to its convenience, comma, upon notice to each other. First paragraph.
My lord, may kindly do not dispose of the CAN application.
Full stop. Paragraph. The above direction is meant for the ends of justice at the prayer of the respondents. Question. He said this application is otherwise wholly devoid of any merit and does not deserve, and no order is deserved to be passed therein in support of the said application. In support of the as prayed for in the application. Full stop. Paragraph. With the above directions and observations, this application, bold can 1 of 2024, stands disposed of.
My lord, let it be kept
without any
pending, my
order
lord.
as to cost.
Lordship, one
My lord,
indulgence. my
let it be kept pending, my lord, because my lord, I'm saying what is the purpose of preferring this application? My lord, this petition is, my lord, for 15 years, there was a first round of litigation.
Sir, choice
lord.
is yours. I will add 2 more sentences and I will dismiss it with exemplary cost. Choice
My
is
lord,
yours.
there were,
Sir, choice is yours. Because you have taken out an application which is out and out of frivolous, mana fide and without any merit. You could have taken out an application for contempt, I would have understood. To accept
My
or
lord,
not to
contempt
accept
was-
is the business of the court.
my lord.
But this type of application shall not remain for a single second on the board.
My lord, contempt was not the only prayer. I prayed, my lord, that either contempt.
Very well, so let me give few paragraphs,
No,
few
well.
paragraphs. I will dismiss it with exemplary cost.
No.
Choice is yours. Choice is yours. There shall be some limit to abuse the process of court. It's a clear abuse. Should I record
No, my lord.
and dismiss
No,
it with
my
cost?
lord, no.
Lordship, one
My lord,
indulgence.
there was only one, my lord, purpose of preferring this
Lordship,
application.
May I, Lordship, one indulgence, my lord. My lord kindly considers the elections are on the verge of. Elections will be at that point
So
of time.
with the filing of affidavit,
My lord, who will sign the affidavit?
model code of conduct will prevent.
My lord, the person should be in the chair.
Will he not be in the chair?
It will be vetted by the ministry, my lord.
Huh?
Respondent number 1, I am for the respondent number 1.
What is his rank, sir?
He is the minister in charge of education, Department of Education.
देखिए, respondent number 1. Let's see.
Lord, Home Secretary, Ministry of Home Affairs.
Ministry of Home Affairs, Home Secretary will
My lord,
not
kindly
find.
give me
No.
some more time so I can bring it because it, my lord appreciates it. Will be some disturbances will be there when the elections are there.
So sorry,
No, my lord, I'm just asking a little more time.
That's all right. You make a prayer, I will consider. But don't say that, sir, that because of the election, he cannot affirm an affidavit.
My lord, I want to be on the safe side. I may not.
No, it's
get-
all right.
I may not.
You pray for extension, I will consider.
That's
not a problem. কি বললো? কবে দিয়েছি ওনাকে সাহেবকে?
15th April, my lord.
24th of April. 24th of April.
24th of April.
15th.
24th of April. Tell me when?
Lordship, another 2 weeks, 1st of May.
15th May.
Lordship.
মে ওটা এপ্রিলটাকে 24th এপ্রিলটাকে মে 15 করে দিন আর রিপ্লাইটাকে মে 30 করে দিন।
Grateful, Lordship.
মে 30 তো ছুটি থাকবে ওটাকে আপনি জুন 10 করে দিন তাহলে ইলেকশনও ওভার হয়ে যাবে।
Grateful. With your leave, my lord.
হ্যাঁ, ঠিক আছে।
হ্যাঁ ওই তলায় ক্যানটা ডিসপোজ অফ উইথ দেওয়া ডিরেকশনস এন্ড অবজারভেশন দিস অ্যাপ্লিকেশন ক্যান বোল্ট করে দিন stands disposed of comma without any order as to cost. Yes,
My lord, my lord,
next.
my lord, in item number 4, I am appearing on behalf of respondent. Due to my throat problem, I am not in a position to argue the case.
Item number 4, what was that?
Item number 5. Item number 5.
Item number 5.
Oh,
Item number 5. Due to my throat problem, I am not in a position to argue the case. Kindly allow short time.
tell me.
Next week.
Next week, my lord.
No
But
problem.
the affidavit and reply, my lord, we kept in record. We'll keep it, right?
Monday, Tuesday.
since the, now, what is your name, sir?
Naveen Barik.
Mr. Nobin
Barik.
Malik
Barik.
Barik, learned advocate, appears for the petitioner. Paragraph. Mr. Ratan Bonik, learned counsel, state counsel, appears for respondent number.
CGST.
Oh, the learned counsel appears for the CGST authority.
DGGI.
CGST authority. Poster. Since Mr. Bonik has been suffering from some throat infection, he is not in a position to make his submissions.
1, 2, 3.
Comma, an adjournment has been prayed for. Paragraph. The club ghar naki. On the poster. Such prayer is not opposed on behalf of the petitioner. Paragraph. On the joint prayer of the parties, the writ petition shall appear under the heading specially fixed matters. Tell me a date. Give me a date. Both of you agree to a date?
Tuesday.
Give me a date.
9th. Tuesday.
On April 9, 2024.
Can it be fixed at 12?
Huh?
At 12. Special. Grateful.
Good.
Grateful.
Item number Lordship, in this matter, I am appearing for the state. I have not received the instruction. Lordship, kindly take it up day after tomorrow.
Passed over for the day. Next.
It will be day after tomorrow.
Passed over for the day. Come tomorrow. Let's see. You might receive by today. Next. Next. Didi Dak.
7, my lord, I appear for the writ petitioner, my lord.
I for the state, my lord.
Very
We have already sought for information, but I have not received it. It only keeps it in next week.
Passed over for the day. Take instruction. Tomorrow I will take up. You have instruction.
I don't want instruction, my lord. This is a case of 107, my lord. The
So let's proceed.
Yes.
Yes. Where is who said? Who prayed for time?
No, in the earlier matter, my lord. My learned friend is in.
Some other, 8.
Oh, it is on 8.
8.
Sorry. Yes. Thank you.
Item 8. My lord, may I file the affidavit of service?
Affidavit of service filed in court today is taken on record. Diggy. What is the matter about,
My
sir?
lord, the petitioner is aggrieved by the decision of the authorities in rejecting his appeal filed under section 107 of the GST Act on the ground of limitation, my lord.
Show me.
Lordship, the impugned order is at page 25.
107.
7, my lord. Here,
Show me the act.
yes.
What is the statutory limitation?
Limitation, my lord, is 3 months, extendable by 1 month.
Extendable.
Yes.
Any extension made?
This is admittedly beyond time.
Any first extension made?
No, my lord. This has been in effect dealt with. The delay, my lord, has been dealt in one paragraph in the
Show me. The provision, let me read first.
107 subsection 1, my lord.
Yes, please read it.
My lord, I'm placing it. Any person aggrieved by any decision or order passed under this act and Services Tax Act, this act or the State Goods and Services Tax Act or the Union Territory Goods and Services Tax Act by an adjudicating authority may appeal to such appellate authority as may be prescribed within 3 months from the date on which such decision or order is communicated to such person.
1 second. Then
Then, my lord, subsection 2.
2.
The commissioner may, on his own motion or upon request from the commissioner of state tax or the commissioner of union territory tax, call for and examine the record of any proceedings in which an adjudicating authority has passed any decision or order under this act, or the State Goods and Services Tax Act, or the Union Territory Goods and Services Tax Act, for the purpose of satisfying himself as to the legality or propriety of the said decision or order, and may, by order, direct any officer subordinate to him to apply to the appellate authority within 6 months from the date of communication of the said decision or order for the determination of such points arising out of the said decision or order as may be specified by the commissioner in his
No,
order.
no, 1 second. So appeal has to be before the appellate authority.
Yes, ma'am.
Then the commissioner will do. Commissioner has a power to call for record,
Yes.
record its satisfaction, and can direct to prefer appeal within 6 months.
Subject to correction by your lordship, my lord, this will be applicable if the department wishes to challenge. the
Challenge.
judgment. Yes.
That's right.
Subsection 1 is for the SSC, my lord.
Correct.
Now, subsection 3, where in pursuance of an order under subsection 2, the authorized officer makes an application to the appellate authority. Such application shall be dealt with by the appellate authority as if it were an appeal made against the decision or order of
1
the
second.
lordship.
Aste. Where in pursuance of an order. Oh, that is under subsection 2.
No, yes, this subsection 3 deals with subsection 2, my lord.
No, not required
Now,
to
my
be
lord,
placed.
subsection 4.
It's an SSC's order.
Yes.
It's an SSC's appeal.
Yes. Subsection 4, my
Yes,
lord,
4.
kindly comes to 4. The appellate authority, if is satisfied that the appellant was prevented by sufficient cause from presenting the appeal within the aforesaid period of 3 months or 6 months, as the case may be, allow it to be presented within a further period of 1 month.
Please.
So this subsection 4, my lord.
Yes. Extension power is there.
Yes, by 1 month, my lord. Now what?
Now let me read the impugned of. Oh,
It is flagged, my lord. 107 is flagged.
yes. Let me read the impugned order.
Lordship. At page 25 of my recommendation.
Correct. 107, 104, then.
Yes.
It is clear from the above that appeal has to be submitted within 3 months from the. Read it.
Yes, yes. It is clear from the above that appeal has to be submitted within 3 months from the date of communication of the order appealed against, and the appellate authority may condone the delay for a further period of 1 month if it is satisfied that the appellant was prevented by sufficient cause from presenting the appeal. Hence, the maximum time limit allowed within which the appeal has to be filed is 4 months. Next page, madam.
And there is, all right.
Internal page 2, my lord. The appellant has submitted the appeal application on 22nd February 2024, and the impugned order has been communicated to the appellant on 14th of December 2021. It is evident from the application. Yes, this is disputed, my lord, whether it was communicated to me or not, my lord, because I have not received any communication. That is my contention.
Then
Now, it is evident that the application has been submitted beyond the limitation period of 3 months and further condonation period of 1 month. A notice has been issued to the appellant on 23rd of February 2024, requesting him to appear before the undersigned on 28th of February 2024 and to show cause why the appeal application should not be rejected on the ground of delay in filing appeal beyond the prescribed period of time. None appeared in response to the notice. It appears that the appellant has no desire to represent his case and has no intention to follow the statutory obligations as prescribed under the WBGST Act of 2027 and CGST Act of 2017. Hence, no further time is allowed. This again, my lord, pausing here, is disputed because I was present there, and before that, my lord, my appeal in writing was already on record. Next paragraph, my lord. It is seen from the records that the appellant has been filing returns under the GST Act regularly in due time without any delay, which indicates that the appellant has been carrying on the business in a regular and normal way without being affected by the ill health and tragedy. Moreover, there is no evidence of the appellant's prolonged sickness and hospitalization, which in turn affecting the
Very good.
overall. Yes.
Yes, madam.
It's clear from the order, ma'am, that the appellate order was communicated on 14/12/2021. And thereafter, this petitioner, my lord, he did not prefer an appeal for more than 2 years, my lord. The explanation to which is required to be given. I, in support of my contention, my lord, there was a division bench judgment, my lord, which says that the condonation of delay has to be properly explained by the person to the authorities. In this case, my lord, he has explained by giving certain medical documents which was not sufficient to clarify.
Now, just clear one point, then it will be in your favor.
Fine.
If you can clear.
Fine.
You show me any material on record that it was served on 14/12/21.
My lord, with regard to that score, my lord, it is in an online portal that the order are communicated, my lord. It was communicated in his online portal, my lord. In that score, if your lordship wants, my lord, I can take an instruction and I can make a report.
Because
to
I
that
tell you
court.
why, I tell you why.
Fine.
It's a statutory remedy.
Fine.
The moment power of extension is there with the appellate authority,
Fine.
that power is obviously there with the 226 court. The basic, elementary.
Fine.
Now, if you really can satisfy this court that the order was put into his knowledge and he was aware of as on 14 December 21, then definitely he does not deserve any condonation. But
Fine.
it has to be a very cast iron proof.
If a report is being called, my lord,
It has to be a very cast iron case. But if you fail to show that, then I will condone. Right?
my lord,
Within 2 weeks, 2 days.
my lord, at least make it Monday, my lord, I'll do that.
No, I will keep it on Monday. Repeat in the meantime.
My lord, will it be lordship's pleasure to keep it on Tuesday, my lord?
I
My
don't
lord-
mind.
my
It's
lord,
your petition.
No, I have
If
some.
you ask for a
I have some
related
personal
hearing, you will
difficulty
ask
on-
for.
Personal difficulty.
I
on
don't
Monday.
mind, sir. I don't mind.
Tuesday.
Ashur. This is a writ petition. Challenging. The impugned order
At page 25.
dated
Fifth
March
of-
5, 2024. Passed by the appellate authority under section 107 of the Central Goods and Services BD. Central Goods, আচ্ছা আপনার ইয়ে চলছে তো BC 107 of the Central Goods bolt করে 107 টাও bold একটা bold the Central Goods C-cap G-cap and Services A-cap S-cap Act A-cap 2017 bracket A for short CGST Act. Whereunder the appellate authority did not accept the explanation of the petitioner being the appellant therein, seeking condonation of delay to file the appeal. Good stuff. The paragraph, the observation material at this juncture, the observation of the appellate authority from the impugned order, which is material at this juncture, is that The appellant has submitted the appeal application on February 22, 2024, data bold. And the impugned order was communicated to the appellant on data bold December 14, 2021, comma, thus it was evident that the appeal was submitted beyond the far beyond the limitation period of 3 months and an extension of and the extendable period of 1 month as provided under subsection
107 subsection 4.
Subsection 4 to subsection 4 কথাটা bold 2 normal section 107 of the CGST Act. Close to.
My lord, it will be WGST Act read with corresponding chapter and section of this CGST Act 2017.
The section is the same, my lord, but the act changes.
Yeah.
So you have shown, you did not show me the West Bengal Act.
Oh, the GST Act, my learned friend is also carrying the GST Act. We all carried that act, my
That
lord.
act.
These sections are same. The name of the act is.
Like
The corresponding provision is also available under the state West Bengal
GST Act 2017.
West Bengal GST Act 2017. Poster. Paragraph. In view of the above, the respondents, who shall file affidavit, madam?
My lord, respondent number 3.
He is the appellate authority who has passed the order.
Respondent number 3, my lord. Appellate authority.
Appellate authority
Will
cannot
Therefore,
file an
my lord,
affidavit.
I think it will be the person against whose order I am aggrieved, my lord.
Why?
No, the first order.
No, the office, the chief of that office who communicated the order. Respondents? You cannot implead the authority, the appellate authority or the adjudicating authority a party.
Then, my lord, it will be respondent number 4.
Deputy Commissioner of Revenue.
Yes.
Madam, you check up.
Because it was his order by which my bank account was freezed. And against that, this appeal has been preferred. At page 17, my lord.
Very well. So he will place the record when it was communicated.
Yes.
কি বললাম? The respondent number 4 shall file a report in the form of affidavit disclosing the relevant materials to show as to when the order under appeal was actually communicated to the petitioner. Full stop. Such affidavit report shall be filed on or before
My lord, on Friday, my lord.
on or before April 5, 2024, upon a copy being furnished to Mr.
To my learned advocate on record, Alok Shah.
To the learned advocate and record for the petitioner. Paragraph. The writ petition shall appear under the heading for orders on
9, if it allows.
April 9, 2024.
My lord, liberty to file exception now or thereafter. But it will is subject to your lordship's
It's a
satisfaction.
question of document to
Document.
be looked into.
Yes.
What she has said, if
Yes.
it is correct, then you have no case. That if there is one official website of yours, what
Yes.
she has said,
Yes, that is what I
if
thought.
there is an official website of yours and it is placed there,
There.
done, you are gone.
Lordship. I'm for the petitioner. Ma'am. Oh, here is my evidence.
এই বইটা ফেরত দিয়ে দিতে হবে, রেখে দিন, ওরা এসে চাইলে দিয়ে দেবেন। আর এই বই একটা আনিয়ে রাখুন তো, দেখে নিন আপনি, জিএসটি আনিয়ে রাখুন, ছবি তুলে নিন দরকার হয়। আর এটা ছবি তুলে দিয়ে দেখান, তাহলেই তো। আচ্ছা বলুন, নেক্সট। Yes,
My lord, kindly say,
what is this serial number?
my lord,
Nine.
item number 9.
Yes, yes, yes.
My lord, I'm praying for a similar order. My lord, kindly see page
What
number.
similar order?
My lord, kindly see page number 83 and 85 of my petition.
The last one,
Last one.
affidavit of service, আসুন আসুন আসুন, filed in court today is taken on record. এটুকু লিখে বসুন, তারপর দেখছি। Yes, page
83 and 85, my lord. Annexure P8.
83.
83. My lord, in this matter, the petitioner was engaged in their respective Madhyamik Shiksha Kendras, that is MSKs as Samprosarok and
You
Samprosarok.
said identical order, GST
Identical.
order?
No, my lord, not GST, my lord. It is another matter. My lord.
Oh, acha, acha, this identical order.
Identical. order.
Oh. Yes,
My lord, the petitioner was engaged in their respective Madhyamik Shiksha Kendras, that is MSKs as
this is
Samprosarok.
65,
60, 65.
60, 65.
83 and 85, my lord. My page.
Age, age.
65, 65.
You take any of my order and bring the copy with corrections. I have at least few hundred on this. Take out anyone. Principal bench, official server, you go there, you take out anyone.
I will.
60, 65 in all matters. Petitioners are different, but Mr. Sarwar Jahan, Learned Counsel, who appears for MSK.
MSKs, my lord.
You call him, take his guidance, anyone, any matter you bring out tomorrow, passed over for the day.
Great.
With the corrections, How many petitioners are here?
My 17, my lord.
So 17.
17.
17 court fees are paid
Yes, my lord.
or one court fee?
No, 17, my lord.
All 17
All,
court fees.
all 17.
Very good.
Lordship, so far this case is concerned, orders are of 2022. Whether they have at all. what
One minute. Hey, Didi, এটা লিখবেন না। এটা ফেরত দিয়ে দিন আজকে। Passed over for the day. Yes.
These orders are of 2022. Whether the present petitioners have availed the benefits, that is, that's we have to ascertain, we have to get instruction. At best, it can be done, they have filed representation for switching over back to the old post. Not, they are not now agreeable to the benefits of parateacher. That can be sent because they
Any averment made to that effect in the writ
No.
petitioner?
No.
No, I have to take
This,
it.
yes. At best, this representative said, because they are applied for switching back to the.
Then you make a representation.
They have already made. At page.
My lord, I have made my representation.
দেখি দিন কাগজ দিন,
It is
শেষ
from
করুন।
page number 67.
Let them consider. Otherwise, in this type of matters,
Yes.
I have at least 100 orders passed.
They have opt for the options.
That's right. I said, at the outset, I said 60, 65. Where is your representation?
My lord, from 68.
81. Last representation.
Last is 80.
At 81.
There are 17 writ petitioners. আচ্ছা, আস্তে আস্তে আসুন। Affidavit of service filed in court today is taken on record. Paragraph. Your name.
My lord, Mr. Sandip Gohara.
Mr. Sandip
Gohara.
Guhorai,
Led by Mr. Sudip Guho.
led by Mr.
Sudip Guho.
Sudip
Guho, my lord.
Guho. Mr. Sandip Gohara, learned advocate, led by Mr. Sudip Guho, learned advocate, appears for the petitioner. Appear for the petitioner. Paragraph. Mr. Hirok Bormon, learned state counsel, appears for respondent numbers.
All the
Respondents. Paragraph. the petitioners. There are 17 numbers of individual petitioners. Post term. Learned advocate for the petitioner has confirmed that respective court fees have duly been paid. You have paid the all 70.
All 70 court fees.
Respective court fees have duly been paid. Paragraph. The petitioners are willing to work as Samprosharok till the age of 65 years. By withdrawing their option already exercised to receive the benefit as para teacher. To receive na. কি বললাম? For working as a para teacher. Paragraph. Learned counsel for the petitioner draws attention of this court. A drawটাকে drew করে দিন past tense. Drew attention of this court to a representation of the petitioners dated November 23, 2023 at page 81 to the writ petition submitted before the respondent number
Two.
mission director.
Mission respondent number 4, my 4.
Respondent number 4 and submits that the same has not yet received the attention of the state authority. Who shall consider? 4. Paragraph. Considering the submissions made on behalf of the parties and considering the materials on record to subserve justice. Na, eta kato, ebar ligo. Mr. Borman Learned State Council submits that how many of the petitioners had really opted to work as para teacher out of these petitioners are not known to the are not known to him right now. And he needs to take instructions in this regard.
One more point. When they have opted, whether they have received benefits of the
Correct.
characters or not. That is to
It is also not known to the Learned State Council right now that whether the petitioners or how many of them have already received the benefits as para teacher and then seeks to withdraw their option. You are for?
I mean, the next matter. Next matter. Similar.
Full stop. Fine. After considering the rival contentions of the parties and upon perusal of the materials on record to subserve justice, the respondent number 4 is directed to consider the said representation of the petitioner dated November 23, 2023. One representation by all.
One more thing, Malad, there is no endorsement as to whether this has been received by.
Forget it. Doesn't matter.
So,
কি বললাম?
Only one petition. না, এখানে
Malad, different representation. Malad, from page number 68 to 81.
All have made separate representation.
68 to
81.
আচ্ছা কি বললাম?
parties and
68.
The representations submitted by the petitioners available at page 68 to 66 to 81 to the writ petition and then shall pass a reasoned order on the issue. Full stop. The respondent number 4 shall issue a prior hearing notice of at least 7 days upon all the petitioners. And then after granting an opportunity of hearing, shall pass the reasoned order. Paragraph. The entire exercise as directed above shall be carried out and completed by the respondent number 4 positively within a period of bold 6 weeks from the date of communication of this order. And then the reasoned order shall be communicated to all the petitioners within a further period of 2 weeks from the date of the said reasoned order to be passed. Paragraph. It is made clear that this court has not gone into the merits of the claim of the petitioners in any manner, and the petitioners shall be at liberty to urge whatever points they wish to urge by relying upon whatever records and documents they wish to rely upon before the respondent number 4. Paragraph. In the event the reasoned decision goes in favor of the petitioner, the appropriate authority shall give an immediate effect thereto and positively within a period of 2 weeks from the date of communication of the said reasoned order to such appropriate authority. Paragraph. It is also made clear that this order shall not create. আচ্ছা কোনো affidavit নেই তো?
No,
Direction হয়নি তো? Paragraph. কাটুন, লিখুন নতুন paragraph. Since affidavits are not called for, the allegations made in this writ petition are deemed not to have been admitted by the respondents. Paragraph. It is further made clear that this order shall not create any right or equity in favor of the petitioners if the petitioners are not eligible to receive their claim in terms of their respective representations, strictly in accordance with law. Paragraph. What else? On the above terms, this writ petition WPA 630 of 2024 stands disposed of without any order as to cost. মাথার উপর চলে যান, ওই যেখানে বলেছি রিপ্রেজেন্টেশন করেছে ফার্স্ট প্যারাগ্রাফ, যেখানে ওর কেসটা বললাম 2 লাইনে, বলুন। কি বলছে, কোন মামলায় কি করলেন এটা? কি আরেকবার বলুন, আরেকবার বলুন, আরেকবার বলুন। অ্যাজ সম্প্রসারক, এ হবে না, পিটিশনের অনেকগুলো আছে। অ্যাজ সম্প্রসারক, সম্প্রসারক as para teachers, plural আছে, এ হবে না, para teachers। তারপর to the representations, petition দরকার নেই, petitioners at pages
from 66 to 82, my lord.
66 to 81 to the writ petition. তারপর
82, my lord.
বাস
The representation is 66 to 82, my lord.
66 to 82. So be sure.
My lord, there are many representation.
Annexure P7.
Annexure P7. Annexure P7 যেভাবে আমি লিখি, Annexure P7 at pages 62 to 60 whatever, কত?
66 to 82, my lord.
66 to 82. দাঁড়ান, এটা কত নম্বর? এটা কত নম্বর? 9। তাও আমি লিখে রাখি আমার অর্ডার কারেকশনের সময়। 66 to 82.
That is annexure P7.
P7 করে দিন, যান, হয়ে গেছে। থ্যাংক ইউ। Next.
Affidavit of service.
একদম মাথায় চলে যান, affidavit of service filed in court today is taken on record.
Next time for the statement.
How many petitioners?
28 petitions.
হ্যাঁ
28.
28? আসুন উপরে চলে আসুন দিদি, ওই প্রথম প্যারাগ্রাফ পড়ুন। 17টা 28 হয়ে যাবে। চলে আসুন লিখুন, পরেরটা লিখুন আপনি 28 petitioners, বাকি এক থাকবে। আচ্ছা, আর annexure?
Annexure P7, page 95 to 122.
1 second. Annexure P7 at pages 95 to
122.
122 to the writ petition. আর তো কোনো চেঞ্জ নেই।
State Council.
কোর্স উপরে নামটা অনার করে দিন, মিস্টার
Nabankur Park.
Nabankur Pal, Landed State Council, appears for respondent numbers
All the state.
for the respondents. চুন মাথায় affidavit of service. Next. Next.
Lordship, item number 11.
আচ্ছা, 1 মিনিট, এটা আরেকবার মিস্টার পাল, annexure P7 at page
Page
97 to
95 to 122.
120. ঠিক আছে, ঠিক আছে ম্যাডাম, চল নেক্সট।
Lordship, I am
11.
I am for the petitioner, Lordship. Lordship, it is the matter of regarding unauthorized construction made by the respondent number 5, Lordship. Lordship,
Where is
sir-
the respondent?
Lordship, service has been made, but
And what about the private respondent?
Lordship, all the respondents has been made except Lordship, private respondent. Regarding the private respondent, Lordship, the service has been written as insufficient address, Lordship.
Has to be served.
Lordship, therefore, I was been informed by the petitioner, Lordship, that due to some error, Lordship, in the pin code, Lordship, so for which the service was
So let me
connected.
understand the case, whether repetition
Lordship,
can survive or not.
it is the unauthorized construction made by the respondent number 5, Lordship. Lordship, if your Lordship kindly,
Then what is your grievance against the police?
Lordship, no, Lordship, actually, the respondent whose land is adjacent to the western side of the petitioner's land, Lordship, they share a common boundary wall, Lordship. So what happened, Lordship, since December 2000.
Let us read the prayer.
Lordship,
A writ in the nature of, read it.
Lordship,
Who is 2, 3 and 4?
Lordship, the public respondents, BDO, BDO Pradhan and Chief Executive Officer.
All right. Demolish the unauthorized building which is being illegally constructed by the respondent without having any space from the boundary wall in the western side of the petitioner's land.
Lordship, the respondent number 5 did not leave any space, Lordship. Your Lordship, if your Lordship kindly come to the page number 39, Lordship. They have been constructing, Lordship, since 2000.
All right, I'll dispose of the writ petition by directing to consider your representation. Has it been considered?
Lordship, once it has been.
Come
No,
on,
no, Lordship.
C prayer B.
Prayer B.
If you strictly harp on prayer A, then I will have I may have my reservation to exercise my writ court power. But B, yes, chalo, ঠিক আছে.
Lordship, written representation regarding.
Has it been disposed of?
No, Lordship.
Pages?
Lordship, pages, representation.
এই দিতে গেলে বিপদ পারবো না।
Page 40, there is a representation. Page 40, there is a representation.
Page 40?
To the SJT.
Dated.
Dated 5th of March 2020.
Page
This is
40.
the, Lordship, that is the last representation made by me, Lordship.
All right, page 40.
That is to be considered by the SJT. We do not represent.
Lordship.
Who is SJD?
Chief Executive Officer, Lordship.
SJT is Siliguri Jalpaiguri Development Authority. Mr. Raja Saha generally appears for the.
Is he a party?
SJDA is a party.
Show me.
Respondent number 4, Madam. The Chief Executive Officer of the Siliguri Jalpaiguri Development Authority.
Respondent 4.
Yes.
I'll direct him.
Okay.
He shall give notice to the private respondents, call everybody
Your Lordship.
Pending রাখার কোনো মানে হয় না আর prayer if you insist for prayer A then I will have to hear on merit I may have reservation.
Lordship, actually, Lordship, being a representation, Lordship, was started from the 27/12/2022. It was firstly been made to the
Show me
Pradhan.
page 40.
Lordship, page 40 is made to
If
the,
your page 40 is decided, you are happy.
yes, Lordship, if the construction
I
has,
will not speak a single, I will not whisper a single letter on construction. The moment you will go for construction to be adjudicated, it will be a civil dispute. But simpliciter, I can direct this representation to be disposed of.
kindly, then Lordship, kindly consider the prayer number B to be,
So you will be happy with prayer if page 40 is directed to be disposed of in your presence.
Lordship.
Right? Okay.
Lordship,
Okay.
regarding the two representation was been prayed for, both representation was been prayed for at prayer B, Lordship.
Where is that other one? Show me.
Lordship, at annexed P8,
Page,
page
page.
36, Lordship.
36.
Lordship.
It is made before whom?
Lordship, it was made before.
BDO.
BDO. Yes, Lordship, these two petitions,
Sir, authority has to be one. So who shall be the authority, Mr. Counsel?
Well, if it is a panchayat area, then the panchayat, under the panchayat act, that plan is approved in the case of any building. If it's a municipal area, then we have.
Lordship, panchayat, Gram panchayat.
Panchayat.
Then the Gram
Show me,
panchayat.
show me the respondent number.
Respondent number 3, Lordship.
Show me. Block development officer.
No, panchayat,
Pradhan
Lordship.
is 3. Then
Pradhan
Pradhan
is-
na Patra kai Gram panchayat.
So Pradhan will decide.
Let the Pradhan.
Correct? He will serve a copy of the writ petition upon Pradhan with this representation. He will decide. Pradhan has been served.
Lordship,
There is already a representation before the Pradhan at page 33.
He will give a copy of this writ petition, so it will be easier.
Lordship, may I make one submission, Lordship, regarding the same? Lordship, Pradhan, regarding the Pradhan, knowledge was been informed to the Pradhan. One hearing was been made regarding the same, Lordship. But that hearing, oral hearing, it was been found that the respondent number 5, yes, verbally it has been stated that he has illegally constructed the land.
Sir, how do I take note of those sitting in a writ court? All verbal things.
Lordship,
So let the Pradhan dispose of
Lordship,
after giving you a hearing.
Lordship, that will be effective, Lordship.
Sorry?
Lordship, that will be.
You are happy.
Lordship.
That's right. Always be happy.
No, Lordship, actually pertinent to mention that, Lordship, earlier the hearing was made, but no effective purpose was been made.
Then how a writ court can take cognizance of that? Page 36
Lordship.
and 40. Page 36, he will decide.
Lordship.
Sure. Right? This writ petition has been filed by an alleged landowner. By a landowner of an by an alleged landowner of the subject land, being the subject matter in the writ petition. Being the subject land na kore, being the land which is the subject matter in the writ petition. Being the land which is the subject matter of the writ petition. The alleged owner alleges that respondent number 5 has constructed an unauthorized and illegal construction immediately adjacent to the property of the petitioner. The petitioner, full stop, the petitioner prays for demolition of such construction. The land is situated within the jurisdiction of panchayat. Of
18 খাই গ্রাম
of
18 খাই গ্রাম
18 খাই এ ভালো করে লিখুন বোল্ড করে ATHARAKHAI 18 খাই A cap গ্রাম G cap panchayat P cap bold, right? Post. Paragraph. মাথার উপর affidavit of service filed in court today is taken out record. 18 খাই হয়ে গেল, তারপর লিখো the respondent number 5 is not represented. Mr. Monirul Rahman. Mominul, লিখেছি Mominul Rahman. Learned State Council appears for respondent numbers.
Respondent numbers 1 and 2.
1 and 2. 3 is also not represented.
No, 3 is the Pradhan. We do not.
Full stop. Paragraph. The respondent number 3 is also not represented. 3 and 4 are also not represented. 4 is required to be heard.
It's JDA, so it falls under JDA.
Required.
It's required to be heard because it is within the SJDA area.
Full stop. Paragraph. Considering the submissions made on behalf of the parties and considering the learned counsel for the petitioner drew attention of this court to a representation dated
21
page 36
Lordship,
August 21 2023. Annexure bold, annexure P8 at page 36 to the writ petition. And also another representation dated March 5, 2024. Annexure P11 at page 40 to the writ petition and submits that those representations have not yet received the attention of the relevant state authorities. Paragraph. Considering these submissions made on behalf of the parties and considering the considering the submissions made on behalf of the parties and upon perusal of the materials on record, to subserve justice, the writ petitioner shall serve a copy of the writ petition with all its annexures upon the respondent number 3.
Respondent number 4. 3 executive.
No. Pradhan.
Well, let the decision be taken by the block development officer. He is the executive officer of the panchayat.
Of?
Panchayat.
video Lordship.
Oh,
Video.
respondent number 2. Kindly look at 2. 2. Before whom this representation 36.
Yes, 36 was
Before whom the representation dated August 21, 2023.
And another representation was also made to the video, that is at page 37.
Is also lying. কি বললাম? Respondent number 2, before whom the said representation is also lying. Poster. Paragraph. The respondent number 2 then, upon issuing a prior hearing notice of at least 7 days to the petitioner, comma, the pradhan of the concerned panchayat, comma, the respondent number 4 and 5, and upon giving them an opportunity of hearing, shall decide the issue by passing a reasoned order in accordance with law. Paragraph. The entire exercise as directed above shall be carried out and completed by the respondent number 2 positively within a period of 8 weeks. কারণ এই সবাইকে সাফ করতে হবে। 8 weeks from the date of receiving a copy of the writ petition along with a copy of today's order. কি বললাম? As directed above. Poster. The respondent number 2 then shall communicate its reasoned order to all the parties concerned positively within a period of 2 weeks from the date of the said reasoned order to be passed. Poster. Paragraph. It is made clear that this court has not gone into the merits of the claim of the writ petitioner in any manner whatsoever, and the petitioner and all other interested parties as directed above shall be at liberty to urge whatever points they wish to urge before the respondent number 2 by relying upon whatever records and documents they wish to rely upon. Poster. The respondent number 2 shall be at liberty to cause physical survey of the adjacent subject property and the alleged construction with the assistance of any parties as he shall deem fit and proper, comma, if necessary. Poster. Paragraph. In the event it is found that it is conclusively found that any illegal construction has been made by the respondent number 5, who shall demolish?
But person opportunity has to be given to the person who has made the illegal construction to demolish it at his own cost.
I have granted respondent number 5. He will be present. No, who shall demolish if it is?
But generally, what happens in case of illegal construction and opportunity is given to the perpetrator or the person who has put up the illegal construction to
I
demolish
have
it and-
given this respondent number 5.
Yes.
Then if it is found after
Then the authority concerned video.
who
The block development.
the panchayat,
Block development officer.
Respondent 2,
Respondent.
full stop. কি বললাম? Any illegal and unauthorized construction is made by file লেখার দোকান is met, comma, the respondent number 2 ভিডিওটা আপনি লিখবেন না, respondent number 2 shall take all necessary and consequential steps strictly in accordance with law.
Well, not including the assistance of the concerned police officer.
To demolish and remove such illegal and unauthorized construction. Full stop. In the event the respondent number 2 is required any police assistance, the jurisdictional police authority shall provide all necessary assistance to the respondent number 2 upon compliance of all the formalities as required to be done in law. Full stop. Paragraph. Since affidavits are not called for, the allegations made in this writ petition are deemed not to have been admitted by the respondents. Paragraph. It is also made clear that this order shall not create any right or equity in favor of the petitioner in any manner, if the claim of the petitioner is not found to be lawful and genuine by the respondent number 2. Yes, but paragraph. On the above terms, this writ petition, WPA 634 of 2024 stands disposed of without any order as to cause.
Grateful, Lordship. Grateful.
Next. আচ্ছা, ওখানে একটা পিরিয়ড করে দিন তো, আসুন ওই ডেমোলিশটা বলেছি, কাম ওয়ে ইজ দ্য পিটিশনার, কি বলেছি ওই ইন দ্য ইভেন্ট যদি দেখায় পড়ুন positively within a period of 2 weeks from the date of the reasoned order to be passed. এই সবকটা পিরিয়ড, টাইম পিরিয়ড গুলো বোল্ড হবে।
Grateful, Lordship.
My lord, one day accommodation paid.
Why?
Senior counsel.
You have also paid accommodation yesterday.
But actually, Mr. Jagrati Mishra, senior counsel out of station, he will come by tomorrow morning. He
No,
will
but
go
you
in all
have
the
paid-
cases.
You have paid for accommodation yesterday also.
Yes, the matter, actually, the reason was same. I have
And
been
how
started-
how the matters will be progressed, how the hearing will be
On
progressed.
tomorrow, my lord.
I could have accommodated other writ petitions.
Tomorrow he will proceed all the.
Passed over for the day.
State is represented, my lord.
Kindly discuss the next week, because my instructions are all the. If it can be placed. Subject to conditions of the shall.
Ashut. On the joint prayer of the parties, the writ petition shall appear under the heading motion on April 8,
Lodge.
April 8, 2024. ওনাদের নামগুলো দিয়ে দেবেন। Give your name. মমিনুল সাহেবের নামটা দিয়ে দেবেন। Next.
My lord, for the petitioner.
In this matter, Mrs. Bose appeared on behalf of the state, my lord. My lord, the report has been called for. My lord, she, due to personal difficulty, she is not in Jalpaiguri, my lord. If you kindly takes it on Monday, she'll submit the report as well on Monday.
On the prayer of Mr. Navankur Pal, Landed State Council, the writ petition shall appear under the heading motion on April 8, 2024.
Grateful, Lord.
When the Landed and the State Council, Landed State Council has assured on instruction that the report shall be filed. Report as directed by this court earlier shall be filed on that day.
Grateful.
ওটাগুলো সই করতে হবে। Item number
For the state.
you ready?
One day accommodation.
Passed over for the day. এর মামলাগুলো কালকে এনার মামলাগুলো সব দেখবেন, উনি যদি না করেন সব উড়িয়ে দেবেন।
He will come back tomorrow.
Sir, these are the opportunity, grab it. If I find any real difficulty, definitely I will adjourn and go for your, I will hear your senior. But why will you not take the opportunity, sir? Do it. Next. One second. আজকে তো মঙ্গলবার। Yes.
I am for the state, my lord.
My lord, I'm for the petitioner. In this matter, the respondents are directed to file affidavit.
My lord, actually, there is a change in parallel recently.
On the prayer of Mr.
Dilip Kumar Agarwal.
Dilip Kumar Agarwal, London State Council, time to file affidavit in opposition stands extended peremptorily till April 30, 2024. Paragraph, affidavit in reply, if any, thereto shall be filed by May 20, 2024. Paragraph, the writ petition shall appear under the heading hearing before the next available circuit bench then, comma, subject to its convenience. Full stop. কি বললাম, the writ petition shall appear? না, এটা কেটে দিন। রিপ্লাই অবধি দিলেন তো, তারপর লিখুন after completion of the above period the parties shall be at liberty to mention for hearing of the writ petition before the available circuit bench then, comma, subject to its convenience, comma, upon notice to each other.
Highly obliged.
Next.
My lord, 16 is the same.
I am appearing for the petitioner, my lords. Before my senior submits, there was a definitely there was a direction for affidavit in December 5th, 2022, 1 year, 3 months back. But now, my lords, this issue is entirely covered because they cannot improve their case over affidavit. Kindly see page number 24. Only on the scope, my lords, the show cause notice does not mention the date, time, and venue of personal hearing. It states NA. And the division bench have said that it is a statutory violation because 75(4) mandates that you have to give a personal hearing if there is an adverse order which is contemplated against the assessee. On those lines, there is an elaborate division bench order, my lords. How will they improve their affidavit?
My lord, actually, I
It
have
is
not gone through this brief because
on the face of the records, my lords. Kindly take
because
page
these
number
all the
24.
factuals should be taken into the affidavit.
Have they taken any coercive step?
No.
Not yet, my lords. But there is no order of stay, my lords. Kindly consider, my lords, this matter may be disposed of.
On the prayer of
Dilip Kumar
Mr.
Agarwal.
Dilip Kumar Agarwal, Learned State Council, appearing for respondent numbers.
All respond.
Appearing for appearing for the respondents. The writ petition shall appear. Now, respondents, time to file affidavit in opposition stands peremptorily extended till April 30, 2024. Paragraph. Affidavit in reply, if any, thereto shall be filed on or before May 20, 2024. Paragraph. Wait, let me complete. I'll hear you if necessary. The writ petition shall appear under the heading hearing before after completion of the above period, aforesaid period, parties shall be at liberty to mention the writ petition for inclusion in the list of hearing before the available circuit bench, then, comma, subject to its convenience, comma, upon notice to each other. Full stop. Paragraph. The record shows that previously there was a direction for filing affidavit on
5th December 2022.
December 5, 2022. And till today, no affidavit in opposition has been filed. And on the contrary, an extension has been prayed for even today on behalf of the state. Full stop. Then the State Council further submits that without affidavit, this writ petition cannot be adjudicated upon. Full stop. Paragraph. More than 1 year has passed. The respondents chose not to file any affidavit in opposition, but prays for extension thereof on the contention that affidavits are required to be placed on record. On the contention that several documents are required to be placed on record. Paragraph. In view of the above, for the ends of justice, time to file affidavit in opposition has already been extended peremptorily as directed above. Comma, however, comma, there shall not be any coercive steps to be taken by the respondents. Without leave of this court.
Well, it's one indulgence you have given.
Without the leave of this court.
Milords, you have given me time till 20 days time has been given to me to file reply. Milords, kindly make it 7th. I don't show. Grateful.
Grateful, my lord.
Yes.
But not today, my lord.
17, Lord, I'm for the successful candidate. But, in that event, Lord, let it be day after tomorrow. Okay. Tomorrow.
Passed over for the day. Remind me if he prays for any adjournment tomorrow.
Lordship, we have been instructed by our senior.
What to do?
By tomorrow morning.
No, tomorrow morning, if your senior does not do the matter, then what will happen?
He will be doing.
Doing.
Grateful.
Next. $18.
Well, I'm for the petition.
Who's there? Yes. Proceed. Agustin. No direction for affidavit?
No.
All right, proceed.
What happened in Denmark? Husband of the present petitioner. Husband of the present petitioner contested as an independent candidate.
Husband of the present petitioner. Who is the petitioner?
Kallani Burman, contested as an independent candidate in the last Panchayat election, madam. And he filed nomination paper. After filing of this nomination paper, all the private respondent, being the member of the running political party, and one of the respondents, the Pradhan of the running political party, madam, came to his house with all the miscreant, entered into the house and shot a fire, and he sustained bullet staining. And there are other 4 persons. They also sustaining it. Thereafter, he was taken. All the victim were taken.
So
to
what is your prayer? To take
No.
them into custody?
Yes, madam. There is a.
Yes.
No, madam. Kindly consider, madam. Kindly consider, madam, this aspect. Thereafter, madam, they are threatening, madam, to withdraw the complaint also, madam.
There is
Madam,
no.
madam,
There is no peace in the family.
But no peace in the madam, in the locality, madam. Madam, kindly see, they also prepared an application for
Husband and wife stay together.
Yes, my lord.
And husband has been attacked. The wife has
But
come for savior.
My lord.
Excellent.
My lord, husband attack, his condition is serious condition, my lord.
Husband's condition is serious.
It's a bullet stain injury, gunshot injury, my lord.
Suffered by husband.
No, my lord. By the private respondent, all the
Who has suffered the injury?
my lord. Suffered injury, my lord, the victim. My lord, he is not.
Who is the victim?
Husband of the petitioner, my lord.
Husband has suffered the bullet.
Yes, injury, my lord.
Firing.
Yes, my lord. Why prefer this writ application, my lord? She made representation also, my lord. But they preferred an application for anticipatory bail before the Honorable High Court.
So I will reject that.
The Honorable Coordinate Bench reject
I will
their
stay. I will stay the anticipatory.
Well, their prayer for anticipatory bail was rejected, my lord. And police did not arrest them. But there is no duty upon the police.
Who has lodged the FIR?
Well, de facto complaint. Present petitioner lodged this complaint.
Present petitioner.
Yes, ma'am. She lodged this complaint.
So husband was attacked. He never lodged.
Well, he was taken to hospital. He was in hospital for many days. How he lodged this complaint, my lord? His statement was recorded by the investigating agency, my lord. Medical document collected, my lord. How he lodged this complaint?
Ashun.
Well, may I just, I know that.
Let me pass the order.
Charge sheet has filed.
I will, sir, I will hear you.
Charge sheet
If
submitted.
you find, I will definitely hear you.
Charge sheet submitted as per my without adding Arms Act also, my lord.
The plea of the petitioner is that the husband of the plea of the petitioner is that her husband contested the last panchayat election. While contesting the panchayat election, the husband became a target of a group of rivals. The husband of the petitioner suffered a bullet injury. The petitioner, as de facto complainant, lodged complaint before the jurisdictional police authority. On the basis of such complaint, from prayer A to the writ petition, it appears that a criminal case was registered, being Dinhata Police Station case number D-cap, P-cap, S-cap, C-cap, number N-cap. Shopta bold away. 345 of 2023. Old. Inter alia under the provisions of sections. Dated. Number dated July 8, 2023. Inter alia, under sections 448 stroke 341 stroke 326 stroke 307 stroke 379 stroke 506 of the Indian Penal Code, ICAP, PCAP, CCAP, 1860, comma the 1860, read with section 25 oblique, stroke 27 of the Arms Act. Full stop. The petitioner claims an immediate arrest of the accused. What happened to Antiwell?
FIR was started. Reject.
The petitioner submits that the accused applied for anticipatory bail before the jurisdictional criminal court.
Before the Honorable High Court.
Before the jurisdictional criminal court, before this court, and the same was rejected. Post. What more?
They are threatening to the complaint.
The petitioner and
If
the
the anticipated bail was rejected, the police is
petitioner,
bound to
her
arrest them.
husband, and all her family members are regularly under threat by the accused. Then what happened?
But till today, police did not take any action.
However, till today, the police authority did not fail to take any step to arrest the accused. Right? Any further? Mr. Joyjit Chaudhary, learned deputy
Additional advocate.
learned additional advocate general for the state, appears for the state respondents. Paragraph. None appears for the private respondents. Paragraph. Learned additional advocate, paragraph. Additional advocate general submits. Charge sheet has already been issued. Submitted. Charge sheet has already been submitted before the jurisdictional criminal court, right?
My lord, yes. And the next date is 12/4/2024.
Full stop. The next date fixed for hearing of the
appearance.
The next date fixed for the criminal proceeding before the jurisdictional criminal court is April 12, 2024.
Then, my lord, already the two persons have been arrested. One is on 18/8/2023.
If other submits that two of the accused, alleged accused,
yes,
are already in custody
and the
are already taken into custody.
And 8, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 8 allegedly accused person had obtained bail from the jurisdictional court.
But were taken into custody. Full stop. About 8 numbers of accused, alleged accused,
obtained bail,
are enlarged on bail by the jurisdictional criminal court. Enlarged on bail. Tapa.
And the remaining accused persons 8, the proclamation has been issued.
Proclamation has already been issued against the rest of the accused.
This is the status.
Paragraph. Considering the submissions made on behalf of the parties and considering the materials on record, this court is of the firm view that the police authority has taken all the necessary steps in accordance with law. The criminal case is being proceeded with before the jurisdictional criminal court. Full stop. Therefore, pending the criminal trial, comma, this court is of the considered view that, comma, the Constitutional Court, in exercise of its power under Article 226 of the Constitution of India, shall not interfere in the given set of facts. Full stop. Paragraph. However, the jurisdictional criminal court is requested to expedite and complete the trial and to arrive at its logical conclusion, preferably within a period of 1 week, 1 year, 1 year from the date of commencement of trial.
Lordship.
Full stop. This court also expects that the trial shall commence soon. Full stop. Paragraph. Since affidavits are not called for, allegations made in the writ petition are deemed not to have been admitted by the respondents. Paragraph. Observation, comma, if any, made herein shall not be binding upon the jurisdictional criminal court, and the jurisdictional criminal court shall proceed independently without being influenced by any observation made by this court. Paragraph. With the above observations and directions, this writ petition WPA 1912 of 2023 stands disposed of. Comma, without any order as to cause. Thank you. I'm coming within 2 minutes. 2 to 5 minutes. I don't know. Yes.
Not today, my lord. Not today. No.
Passed over for the day. Twenty. None appears for the petitioner nor any accommodation has been sought for. Paragraph. Unananta diye Mr. Hawk, learned, learned State Council is present. Paragraph. The writ petition shall appear under the heading motion before the next available circuit bench, comma, subject to its convenience. Next.
21 I appear for the petition. Lord, this is an application for inaction of the police. Lord, simple application. The FIR was registered in the month of May 22. Lord, to our knowledge, after that, the police has taken no steps.
Who's for the state? Digi, count it. Report filed.
No, we're fine. Yeah, with the original.
Mr.
Shubham Ghosh.
Shubham Ghosh, learned counsel for the petitioner, referring to the first information report, Annexure P1 at page 10 to the writ petition, submits that police case registered.
Yes.
Though the case has also been already been registered as
Lordship,
Lord, Shiliguri PS case number
Siliguri PS case number
445 of 22.
445 of 22,
dated 9th May 2020.
2022, dated
9/5/2022.
May 9, 2022. But thereafter, the police authority, jurisdictional police authority is reluctant to proceed with to take any further steps. Paragraph, steps, full stop. Hence this writ petition. Paragraph, Mr. Hirok Bodmon, Learned State Council, appears for respondent numbers.
One, 2, 3.
1, 2, 2, 3. Full stop. The private respondent, being a juristic entity, being a juristic person, is not represented. Being a juristic person is not represented. Paragraph. The State Council submits a report, a detailed report before this court today, comma, the same is taken on record. The report shows that
Already 161 statement has been recorded of the witness.
that statement under section 161 of the Code of Criminal Procedure has already been recorded.
The bank accounts of the accused person has already been freezed.
The bank account, full stop, the bank account of the accused has been freezed
along with certain documents under proper legal list.
and the police authority has also taken possession of some relevant documents and materials from the alleged accused. আচ্ছা, ওখানে alleged accused, bank account of the alleged accused, right?
Yes.
তারপর কি? দিদি এটা কত চলছে 27 ঠিক আছে তাহলে এটাকে একটু নামিয়ে দিন পেনটা আমার মাথায় লাগছে কি বললাম বাস alleged accused charge sheet
No, charge sheet has not been filed. Notice has also been sent under section
41.
41A, Lords.
Notice under section 41 of the Criminal Procedure Code has also been served.
But as the details as furnished by the complaint, the address was not correct, so it could not be served.
It's a registered address.
আচ্ছা কি বললাম has the Criminal Procedure Code was sought to be served at the address provided by the complainant.
Lord, kindly mention that it's a registered address because it's a company.
But since the address being incorrect, the same could not be served. Full stop. Then
Lordship, permission has been sought for from the concerned authority for visiting because the accused is of Haryana, of the state of Haryana.
the police authority has also taken steps in accordance with law to know the whereabouts of the alleged accused who is stationed at Haryana. That's all.
Proceeding, charge sheet has not yet been filed.
Full stop. Learned State Council, paragraph. Learned State Council on the query of the court submits that charge sheet is yet to be prepared. Paragraph. What's your name, sir?
My Lord, Shubham Ghosh.
Mr. Shubham Ghosh, Learned Counsel for the petitioner, submits that the address of the alleged accused provided to the police authority was as per the
Companies Act. My Lord, the
registered address.
Yes, sir. Registered address of the company.
As per the is the office of the registered office, is the address of the registered office of the company as per the record maintained by the register of companies. Full stop. Paragraph. Learned Counsel for the petitioner submits that the jurisdictional police authority is inactive and hence such inaction of the police authority is complained of through this writ petition. Paragraph. Considering the submissions made on behalf of the parties and considering the materials on record, it appears to this court that the jurisdictional police authority has already taken steps in accordance with law. Full stop. The police authority shall prepare and issue the charge sheet positively within a period of 4 weeks from the date of communication of this order in accordance with law.
Let it be 8 weeks because they are anticipating for moving to Haryana.
4 weeks. যা বলেছে
6 weeks.
6 weeks.
They are busy.
6 weeks. Don't take all these plea. কি বললাম? You pray, court will accommodate. Court will accommodate its officer. No.
Great.
কি বললাম? And issue the charge sheet. And issue na submit বলে। And submit the charge sheet. Prepare and submit the charge sheet before the jurisdictional criminal court. Charge issue. Prepare and submit the charge sheet before the jurisdictional criminal court positively within a period of 6 weeks in accordance with law from the date of communication of this order. পড়ুন এইটা আরেকবার। ঠিক আছে, ঠিক আছে, ঠিক আছে। The jurisdictional police authority shall expedite the process forthwith. Full stop. So that the police case already registered can reach to its logical conclusion at the earliest. Paragraph. Since affidavits are not called for, allegations in this writ petition are deemed not to have been admitted by the respondents. Paragraph. Observation, paragraph. Observation, comma, if any, comma, made herein shall not be binding in any way upon the jurisdictional criminal court where the trial shall commence. Paragraph. With the above observations and directions. This writ petition number কত? WPA
2896.
bold করে দেবে না? Stands disposed of, comma, without any order as to cause. Next. None appears for the petitioner, nor any accommodation has been sought for. Yes.
My lord, this is serial number 23 or 20. 23, my lord, I am for the petitioner. In serial number 20.
22.
No, this is not my matter. 22 is not my
None appears for
matter.
the petitioner, nor any accommodation has been sought for. Paragraph. Learned State Council is present. Give your name.
I am for the DPS, District Primary School Council.
Paragraph mention, Mr.
Subhashish Misra.
Subhashish Misra, Learned Council appears for respondent numbers.
Siliguri, my lord. Respondent number 5, my lord.
5. Paragraph. In view of the above, the writ petition shall appear before the next available circuit bench, comma, under the heading motion, comma, subject to its convenience. Next. Twenty-three.
I'm for the state. You're for the university. I don't think one thing on it. Direction.
একটু unmute করে দিন।
File an affidavit in opposition. And what has happened when the university is in ground rules for the last 2 months? The VC has left. VC is not there. This is an interim VC.
What is the matter about?
Suspension, my lord.
Lord, may I submit, Lord? Lord, may I be permitted to submit, Lord? Lord, the petitioner before your lordship, Lord, is an associate professor under the North Bengal University in the discipline botany. Now, Lord, on the basis of a complaint of a Lord, junior fellow researcher, Lord, a complaint was made against the associate professor, Lord,
Is the
for
complainant-
sexual
is the-
harassment.
Is the complainant is the complainant impleaded?
Lord, complainant has not been impleaded. Now,
Very
Lord,
good.
thing is this, Lord, based on the recommendation, based on the recommendation of the ICC, Lord, your lordship, kindly have a look.
What's your
I
name?
have filed one application.
What's your name?
Lord, I am Dibendra Narayan Ray.
Oh, I'm so sorry, Mr. Ray. You were not visible properly. I'm so sorry.
I'm, Lord,
Mr. Dibendra
already I'm
Narayan Ray, Learned Counsel, appears for the petitioner through virtual mode.
Lord, may I only submit, Lord, one thing, Lord.
Yes.
Lord, suspension order, Lord, is being prolonged. Lord, it is more than 3 months. Now, Lord, in view of the decision of the Honorable Supreme Court, Lord, reported in 2015, 7 Supreme Court cases, page 29.
Sir, first
page two-
implead, then I will hear you. But what is the application for?
Lord, application for, Lord, revoking the order of suspension so that I can join the university.
Very well.
Because I have
First implead, then I will hear you. Then the court will hear you. Ki bolam?
this can be done, Lord, here and now, because the learned advocate on record is physically
Yes,
present
I
before your
will grant
lordship.
you leave. I will grant you leave. Then you will serve. Then court will take it.
Yes.
Virtual mode. Paragraph. Mr. Nobankur Pal, Learned State Council, appears for respondent numbers
1.
1. Mr. Nobin Barik, Learned Council, appears for respondent numbers 2 to 5. Paragraph. On the perusal of the writ petition, it appears to this court that the petitioner has challenged the disciplinary proceeding.
Lord, that has not been initiated at all. Only I have been placed under suspension based on the recommendation of the.
A petitioner has challenged the decision of his suspension taken by the concerned university, where the petitioner was working as an assistant professor.
Associate
Professor.
Yes.
The cause for suspension was a complaint submitted by a lady, junior research fellow, and the allegations are sexual harassment.
Internal complaint committee was formed.
So paragraph. The petition shows the complainant has not been impleaded. No erection for affidavit has been met previously. Paragraph.
The impugned order is at page 25.
Full stop. You will know.
Was a complaint and the allegations has not no direction for evidence has been made to this.
In the writ petition. This court is of the firm opinion that the complainant is a necessary party in the writ petition, and an opportunity must be given her. An opportunity of hearing must be given her, must be given to her. Paragraph. Accordingly, leave is granted to the petitioner to implead the complainant.
And section 16 will come into play, we are reflecting our name.
Oh.
That is there. X, it has to be Miss X or X.
দরকারই নেই, ছেড়ে দিন, অন্যভাবে করতে হবে। বলুন। না, দরকার নেই, কি বললাম? Thank you, thank you, thank you, thank you, thank you, thank you so much. কি বললাম? Has to be granted an opportunity of hearing. But in view of the rigor imposed under section 16 of the
Sexual Harassment Act.
Sexual Harassment Acts.
But women at workplace. Women at workplace.
Give me the act.
Sexual harassment of women at workplaces.
Just give me. Where can I get it? Which page?
Page 26, first paragraph.
One second, sir. Thank you so much.
Page 26, first paragraph, last folder.
আগে লিখে ফেলুন তো, দেখে এই একটা আন্ডারলাইন করেছি, দেখে আগে ভালো করে লিখে ফেলুন।
Cannot pass. And this is it will be that act, but it is also covered by this rule. This is, my lord, the university has framed the rules under that act. It's called, my lord, it's University Grant Commission.
No, I am simply recording why I cannot imply. কি বললাম? Rigor না করে in view of the restrictive provision. Paragraph for short, the said 2013 Act. Comma, she cannot be impleaded in a regular manner. Poster. A copy of petitioner is directed to serve a copy of the writ petition upon the complainant.
To the university, my lord.
Why?
My lord, if he sends to the copy to the complainant, it has to be by a name.
A writ petition can be served upon.
My lord, in fact, Lord, the petitioner is aggrieved, Lord, not against the complainant, but against the report of the ICC. The report of the ICC is the subject matter of challenge in the present writ petition, Lord.
No, but the complainant has to be heard.
Complainant, Lord, was heard before the ICC, Lord,
That's right.
based on.
That's
So,
right.
Lord,
she must file an affidavit. কি বললাম? আচ্ছা, পিটিশনারও বাদ দিন, কমা, ইউনিভার্সিটি রেসপন্ডেন্ট নাম্বার
My lord, from 2 to 5.
2 to 5.
2 is the vice chancellor, my lord.
Who is the registrar?
Registrar is 3.
কি বললাম? না petitioner কেটে দিন। The respondent number 3 is directed to furnish a copy of the complete set of writ petition before the to the complainant, so that the complainant can file an affidavit in opposition thereto. Paragraph. The respondents present today in court pray for an extension of time to file their affidavits in opposition. You have also.
There was no direction about me.
All right. Paragraph. Accordingly, time to file affidavits in opposition by the respondents stands peremptorily extended till April 30, 2024. Paragraph. The complainant shall also file her affidavit in opposition to the writ petition on or before April 30, 2024, in accordance with law. Paragraph. Affidavit in reply, if any thereto, shall be filed. কি বললাম? On or before May 10, 2024. Paragraph. After completion of the aforesaid period, the parties shall be at liberty to mention the writ petition for hearing upon notice to each other before the next available circuit bench, then, comma, subject to its convenience.
We have filed a can.
But only,
Have filed a can.
but
Let me sharpen.
Yeah, do it. The interlocutory application shall also be served
yes,
upon the respondents, and in turn, the respondent number, your melody. 3. The respondent number register is 3. And in turn, the respondent number 3 shall also serve a copy of the said interlocutory application upon the complainant. And the complainant shall be at liberty to file our affidavit in opposition thereto also within the time frame indicated above.
but the one thing that I should be permitted to submit, that the petitioner is under suspension, which I have already submitted for more than 3 months, but that is not without initiation of proceeding, departmental proceeding. The prolonged suspension is bad in view of the Supreme Court decision.
All
Now
right.
the thing is this, not although that although I am under suspension, I am being compelled to attend regularly. I am being compelled to attend regularly, but this should be stopped, Lord.
That I
But
cannot,
today-
without hearing you, I cannot do that. Next.
So it's a officer. ঠিক আছে, same day, আন্দোলনের মধ্যে পুরো ব্যাপারটা কমপ্লিট করতে হবে। 30th এর মধ্যে অপোনেন্টের মধ্যে AR করে liberty to mention before the next available circuit. Yes.
Yes.
Not today, my lord. Not today. Matter may be fixed for tomorrow.
Ask to.
25 I am for the petitioner.
Yes.
My lord, I am for the school service
Well, I am appearing for respondent number 23, my lord. I am led by Ms. Sutoba Sannal, my lord.
Hey, item number, my lord, is it 24? Is it 20? My lord, I am for 25.
Yes. Who
My
is?
lord, it is it. Yes,
Who is
25.
appearing
My lord,
for
I
the
am.
petitioner? 25. Who is
My
for
lord,
the petitioner?
I am for the petition. I am
What's
for
your
the
name?
petition.
What's your name,
My
sir?
lord,
School service commission.
Sudeep Ghosh Chaudhary.
এই একটুখানি
Sudeep
এটা
Ghosh
এগিয়ে
Chaudhary.
দিন না এই মনিটরটা একটু এগিয়ে দিন Yes, what's your name?
Sudeep Ghosh Chaudhary. my lord.
আচ্ছা Mr. Sudeep
Sudeep
Ghosh Chaudhary, Learned Counsel, appears for the petitioner.
Acha.
Then you are for next.
My lord, I am for the school service commission, my lord.
Acha, Mr. Sunit Kumar Rai.
Yes, my lord. My lord, I am assisted by Mr. Mishro, my lord. Subhasish Mishro, my lord. He is there, my lord.
Give the names. Give the name. Mr. Sunit Kumar Rai, Learned Counsel, appears for respondent numbers
My lord, respondent number 3.
3. Then next. Mr. Pritam Das, Learned Counsel, appears for respondent number 1 and 4. Mr. Shondip Guhorai, Learned Counsel, appears for respondent number 5 and 6.
Yes.
Yes.
My lord,
Who appears for 3? 3 and 4.
Mr.
My lord, I am for the 3, my lord.
Online on behalf of the respondent number 3, I am assisting him.
3.
Yes.
And 4? What's your name? Mr. Anirban Rai. Anirban Banerjee, Learned Counsel, appears for respondent number 2. Then who is 4? I've recorded. Chalo. Yes, what is the matter about?
my lord, matter is, my lord, transfer of petitioner from one school to another school. But what happened in this my lord, at presently in the school there are, my lord, 8 Bengali teachers. 8 Bengali teachers. And what happened, my lord? I made an application in the Utsri portal, which has been backed by the school authority on the ground of 10% rule. My lord, I have averted in paragraph number 7. My lord, 40 when
The service filed in court today is taken on record. There is no scope for any interim order. Let affidavits be exchanged. Ashut.
yes, my lord, only one point, my lord, I have stated, my lord, there are, my lord, 43 teachers at the relevant point of time. 4 teachers got transferred, but as per 10% rule, 5 teacher, 4.3, that means action to be treated as a
Very well,
next higher decision.
let me consider an affidavit. Ashut.
Yes.
Considering the issue
In the paragraph number 7.
Considering the issue involved in this writ petition, this court is of the considered view that there is no scope for any interim order. And affidavits are required to be called for.
Lordship.
Paragraph. Affidavit in opposition shall be filed on or before
My lord,
May 12, 2022. 24.
Great.
May 2024. Reply if it is there to on or before June 10, 2024. Paragraph. The writ petition shall appear under the heading hearing before the,
My
sorry,
lord,
parties after completion of the aforesaid period, the parties shall be at liberty to mention,
lordship,
include the matter in the list of hearing.
My lord, instead of hearing, let it be in motion.
Before,
Only this much.
before the next available circuit bench then, comma, subject to its convenience, comma, upon notice of each other.
Grateful, my lord.
Next.
Lordship. My lord, 26 will have time for the petitioner. My lord, this is.
My lord, I am for the School Service Commission.
Same.
No, my lord, this is different. My lord, my application reached to the School Service Commission. That should be considered in accordance with law. I am relying on judgment, paragraph number 17 of the coordinate bench. My lord, Uchchasri status, your lordship, Uchchasri status, your lordship may find page number 15. It has been reached to the SSC, but it has not taken any decision.
Where page, which has reached?
Page 15, 15, 15.
15.
Yes.
It is a Google map.
No, then 16. Next page, after Google map, my lord. 16. Yes, my lord, 16.
Full stop. Shower
My
appearance.
lord, my lord, in this matter, my lord, I want to rely one judgment of the Honorable Division Bench of this Honorable High Court. My lord, Mr. Mishra is there, my lord. Kindly hand up the judgment passed by the Division Bench.
You take all those points before the authority.
Yes.
Who shall consider? Respondent
My
number?
lord,
Respondent number 3, my lord. School
My lord,
chairman, School Service Commission.
Yes, Mr. Ray.
Respondent.
my lord, kindly, then, my lord, if your lordship is directing the School Service Commission, then, my lord, kindly consider the judgment passed by the Honorable Division Bench.
I will give you leave. You proceed. You place those judgment before the chairman. Who
Yes.
shall consider?
And so
Respondent number
liberty
3.
also given. Yes.
Respondent number 3.
3.
Ashun. The petitioner through Utsosri portal has applied for transfer from one school to other. Has applied for transfer from one school to other. Paragraph. Mr. Shudip Ghosh Chaudhary, learned counsel for the petitioner, referring to annexure P7 at page 15 to the writ petition, submits that the application of the petitioner is lying before the
West Bengal Central School Service Commission.
Before the West Bengal Central School Service Commission. And has not yet received any attention of the authority. Paragraph. Considering the submissions made on behalf of the parties and considering the materials on record. Now, এটা কাটুন এবার লিখুন Mr. Shunit Kumar Ray, learned counsel appearing for respondent numbers
3, my lord.
3, my lord.
3 submits that the law is well settled on the issue and the said transfer cannot be done.
And my lord, another thing, my lord.
Yes.
My lord, and the portal is also suspended, my lord. The designated portal is also under suspension.
The Utsosri portal stands suspended. Full stop. Paragraph. Learned counsel for the petitioner also submits that he shall also rely upon a judgment showing that the petitioner is eligible for transfer.
Lordship.
Full stop. Paragraph. After considering the rival contentions of the parties and a perusal of the materials on record, to subserve justice, comma, the respondent number 3 is directed to take a decision and then shall pass a reasoned order on the issue. Paragraph. The respondent number 3 shall issue a prior hearing notice of at least 7 days upon the petitioner, comma, the respondent number 4, comma, respondent number
5.
5
also.
5, and then after granting them an opportunity of hearing, shall pass its reasoned order. Paragraph. The entire exercise, as directed above, shall be carried out and completed. Shall be carried out and completed by the respondent number 3 positively within a period of 6 weeks from the date of communication of this order. 6 weeks kotota bold. The respondent number 3 then shall communicate its reasoned order to the petitioner and all other interested parties positively within a further period of 2 weeks from the date of the said reasoned order to be passed. Full stop. Paragraph. If the reasoned order goes in favor of the petitioner, then the appropriate authority shall take all consequential steps to give effect thereto immediately, but positively within a period of 3 weeks from the date of communication of the said reasoned order to such appropriate authority. Within a period of 3 weeks from the date of communication to such appropriate authority. Paragraph. It is made clear that this court has not gone into the merits of the contentions of either of the parties raised before this court. And the parties who shall participate in the hearing shall be at liberty to urge whatever points they wish to urge, relying upon whatever records, documents, and judgments, including the relevant provisions of law, they wish to rely upon before the respondent number 3. Paragraph. Since affidavits are not called for, the allegations made in the writ petition are deemed not to have been admitted by the respondents. Paragraph. It is further made clear that this order shall not create any right or equity in favor of the petitioner if the petitioner is not eligible to receive his claim strictly in accordance with law. Paragraph. On the above terms, this writ petition, bold, WPA 393 of 2024 stands disposed of without any order as to costs.
My lord, be grateful.
Great.
Thank you.
My lord, next matter I am praying only leave. My lord, on tomorrow I shall do it.
Next.
My lord, next matter I am praying leave. Tomorrow I shall do it. My lord, I am taking password for this gate only. My lord.
My lord, I am for the Central School Service Commission.
Passed over. passed
Lordship,
over for the day.
extremely great.
Next,
My lord,
Yes.
item number 28, my lord, I am for the petitioner.
28, Kagos Din.
My lord, I am for the petitioner, my lord.
What is the matter about?
My lord, petitioner initially applied under the post of the Anganwadi helper. My lord, advertisement done. My lord, according to the advertisement, petitioner being an eligible candidate, filled up the form, admit card are issued. My lord, interview was done, and subsequently I was declared as a number one in the panel. Subsequently, my lord, since no appointment letter has been given to the petitioner, my lord, the advocate on record made a representation before the authority. The authority has rejected the prayer of the petitioner, but without granting any opportunity of hearing to the petitioner.
Where is
Only
the,
on the
where
my
is
lord,
the where is the representation? Where is the fate of it? Show me.
my lord, just 1 minute, my lord. Before that, my lord, just 1 minute. My lord, he refused my prayer only on the ground that I am not a resident of that Gram Panchayat. My lord, I have all the documents with me to show that I am the resident of that Gram
Show me
Panchayat.
the representation and the fate of it.
Thereafter, my lord,
Which
first, my
page is
lord,
the representation?
my lord, page 31 is the first representation.
Which representation was decided by the impugned order?
My lord, it was not, any representation has not been decided.
Show me the impugned order.
My lord, page 27. May I pray one indulgence, my lord? One indulgence.
Yes.
My lord, thereafter, my lord, I made a representation along with all the documents that I have the resident of that Gram Panchayat. Since those documents
Which
has not
page?
been, my lord, that is page 34. Along with papers that I had the resident of that Gram Panchayat. At that juncture, I just want to pray before your lordship, kindly give the CDPO a order for hearing me, and after granting any opportunity of hearing, if any order passed, my lord, I have no grievance. But kindly grant me any opportunity of hearing to show my document before the authority. Nothing more than that. My lord, only considered my representation at page 30.
Then what will happen to 27?
My lord, by candidly saying, my lord, my advocate on record made a mistake. I should admit before your lordship that order should have been challenged. My lord, that order has not been challenged by
That's
the
precisely I'm saying.
petitioner.
That precisely I'm saying.
What if the impugned order goes in favor of me, then automatically it was set aside.
No,
If it
no,
is
no. Then
not
that
being,
cannot be.
if
That cannot be. So the situation comes, and writ petition is disposed of, and without challenging that, you prefer go on appeal without challenging or claiming set aside, and then you say or you file a second writ petition without praying for recalling and say that let that order remain. If you pass an order, it will be superseded.
no, my lord,
Amend your writ petition, then move it.
my lord, my learned advocate on record is inside, my lord, the court, my lord. If your lordship
You
kindly
amend the writ petition in the way you take out a proper application. Or you withdraw this, I am granting you leave to file afresh. Choice is yours, tell me.
kindly grant me leave to file afresh.
Mr. Gaurav Das, Learned Counsel, appears for the petitioner. Paragraph, Mr. appears for the petitioner through virtual mode.
Pritam Das.
Mr. Pritam Das, Learned State Counsel, appears for respondent numbers
1, 2, 3, and 8, my lord.
1, 2, 3, and 8. Paragraph. Mr. Das, Learned Counsel for the petitioner, in his usual fairness, has pointed out that the order impugned by which the petitioner is aggrieved, dated January 2, 2024, Annexure P6 at page 27 to the writ petition has not been challenged, neither any prayer has been made for quashing of the same. Paragraph Naushangi. Learned counsel for the petitioner submits that so though sufficient materials are already appended to this writ petition to show that the said impugned order is liable to be set aside, and the issue can be remitted back before the authority concerned to reconsider to revisit the case of the claim of the petitioner. But since no prayer, no appropriate, but in absence of the appropriate relief claimed in this writ petition, but in absence of appropriate relief claimed in this writ petition, but in absence of appropriate relief claimed by the writ in this writ petition, the same cannot be done.
The prayer I have made in the
Paragraph. On instruction, comma, Mr. Das prays for leave to withdraw this writ petition and to file afresh on the self-same cause of action. And to file a fresh writ petition on the self-same cause of action with appropriate reliefs. Paragraph. For the ends of justice, such prayer is granted. Paragraph. WPA 570 of 2014 stands dismissed as withdrawn with leave to file afresh on the self-same cause of action with appropriate reliefs.
Great.
I'm for the petition.
I'm for the state.
Kagus did.
Oh, your side will go. Will find a supplementary, my lord. So the issue is, my lord, the petitioner before lordships obtain a license, forest license under the general category.
License for?
Forest license.
Forest license.
Under
Sawmill.
Just under general category, by which he can run the sawmills and he can use the raw material. This license prescribes, rules prescribes. Now issued by this general license, petitioner was also running a business of furniture units. Now the issue is whether on the strength of a forest general license, the petitioner can install a machinery which is required for manufacturing furniture. They have rejected my prayer. My issue is that I holding the license on the general category by which I'm running the sawmills and also using the raw material on the rule says, by which general license can I be allowed to install a machinery which is required for furniture unit. This is the issue. If they have rejected my prayer, you also kindly
show me the rejection.
You also can come to page 19. Sorry, man. Sorry.
Page 47.
No, please. Please. Sorry, man. Page 46, man. 47. Page 47, man. What is?
Yes, sir.
I said that this order with reference to the above subject, this is to inform you that as per Form 1, you are only allowed to run the unit issuing timber as raw material. Hence, your prayer is here rejected.
Where is the reason?
Then, no reason. You are directed to stop manufacturing furniture without prior clearance from the undersigned. This is the order, man. I applied for this is my prayer at page 46. I prayed for installation of a machinery for wood engraving, that at page 46.
So on page 46, the decision at page 47 came. That's right? Let them revisit the issue.
My lord, I just subject law, I just place the law, my lord. If you kindly.
Then you have to on affidavit.
No, they filed the report.
File the report. Better go back. Within 4 weeks, they will give you a hearing and reason order.
My lord, kindly authority, my lord. No. Your Worship, kindly can make divisional first officer. He is the
R.
Divisional first officer. 3, my lord.
R3.
Yes, my lord.
Ashu. The writ petitioner is a licensed. The writ petitioner is a licensed sawmill operator.
The language is opted the license on the general category.
Kindly sees the license, Manoj. Page 30.
General
Page
category.
38.
Yes. Yes.
The writ petitioner
Opted license for running a sawmill under general.
That's right. Is a licensed sawmill operator under the general categories. Comma, annexure P2 at page 38 to the writ petition.
Yes.
The petitioner was willing to install necessary equipment and machinery which are essential for running his business.
No, which is essential for furniture business, manufacturing furniture.
Page 46.
Which are essential for running his furniture business, manufacturing of furniture.
Under the
business.
secondary unit. This is called secondary unit.
Under the secondary
unit.
But he has no license for secondary unit.
Under secondary category.
Under the secondary category.
This is decided.
Full stop. I'll record your submission. Secondary category. Paragraph. Drawing attention to the representation dated
12
December 15, 2021, annexure P7 at page 46 to the writ petition. Mr. Omolesh Rai, learned counsel, submits that the said representation was submitted before the respondent number 3. Respondent number 3,
order was then that should
who in turn passed its impugned order dated April 11, 2022, annexure P8 at page 47 to the writ petition, rejecting the claim of the petitioner. First up.
Then two is the principal chief conservator, because 3 is a serious to serious wife. 2 is the highest authority.
No.
The same authority will consider.
No, not required. Higher authority can.
Two is the.
Yes.
The divisional officer, forest officer is the concerned authority who can consider the presentation. Because
let it be done.
He has once passed the order. You know, sir, it's a serious to serious wife. 2 is why.
What about if it is by 2, how does it matter?
2 is the highest body.
If it is by 2, how does it matter?
He lose the right to appeal.
Yes. Then that I'm not concerned. There is no departmental appeal, but this is a concern.
Very well. I will record his submission that he concede to that. It is his submission that you shall consider. Take action.
It is a policy matter.
আজকে ঠিক 3 10 কি দেবেন আমাকে মনে করে ফুল কোড রেফারেন্স আছে
state representative or candidate before the basis number 3, who in turn passed his refused order dated April 11, 2022, and except 8 and 8 considering rejecting the claim of the petitioner.
Paragraph. The said impugned order dated April 11, 2022 is under challenge through the instant writ petition. Paragraph. Mr.
Nabankur Pal.
Nabankur Pal, Learned State Counsel, appearing for respondent numbers.
All the respondents.
Respondents submit that the petitioner does not have any secondary license. Poster. He submits that the order impugned is just and lawful and was passed after considering all the materials before the respondent number 3. Paragraph.
Then logically, my issue is that logically take this, a person having a general license is entitled to run a furniture unit. The rules contemplates that. This is my issue.
Deny par contra, paragraph, par contra, comma, Mr. Learned Counsel for the petitioner submits that that
a person having a license under general category.
Okay. That a license holder under general category, as the petitioner in the instant case, is eligible to run a business for manufacturing of furnitures.
The secondary unit.
Under?
As a secondary unit.
As a secondary unit.
In terms of the rules or rules are based
In,
on
rules
under the law, under the law. That is a submission, sir. Don't worry. Under the law. Paragraph. After considering the rival contentions of the parties and upon perusal of the materials on record, and specifically on a close scrutiny of the impugned order dated April 11, 2022, it appears to this court that the order impugned is too cryptic, T-double-O, cryptic. The reasons are not specified as they should have been in the light of the prevailing rules and law. Poster. Paragraph. Thus, this court is of the considered view that the said order impugned dated April 11, 2022 cannot sustain in law. Poster. The order impugned dated April 11, 2022, Annexure P8 at page 47 to the writ petition stands set aside and quashed. Set aside bold, quashed bold, and turn normal. Paragraph. However, sub justice as
since the divisional forest officer is the authorized officer prescribed under the rules manner, he has to consider it.
that the very well let it considered by
You're appreciate.
No. Then show me the law.
No, I just submit to the law.
No, submission will not do, sir. If he is the authorized officer, he will have to.
That's submit. What is the authorized officer?
Kindly see the definition, Madam.
Yeah.
Very well. No,
you lost it. Actually, you lost it. Just what I'm trying to submit. He is correct. Under the law, he is the license authority. Authorized officer is a license authority under rules. When he pass the order, my lord, you lost it.
Not required. Let him. Let him follow my direction. Then whatever will come, he will challenge again, if necessary.
Yes.
And if you are granted,
I accept my junior's submission. Okay.
কি বললাম? However, to sub justice, the respondent number 3 is required to revisit the issue strictly in accordance with law.
After giving me opportunity, sorry, much.
Accordingly, the respondent number 3, upon issuing a prior hearing notice of at least 7 days to the petitioner and anyone else,
The range officer.
and the respondent number 4 shall revisit and decide the representation of the petitioner, annexure P7 at page 46 to the writ petition, after affording an opportunity of hearing to them by passing a reasoned order in accordance with law. Paragraph. The entire exercise as directed above shall be carried out and completed by the respondent number 3 positively within a period of 4 weeks from the date of communication of this order. Paragraph. Paragraph no সঙ্গে. The respondent number 3 then shall communicate its reasoned order to the petitioner and the respondent number 4 positively within a further period of 2 weeks from the date of the said reasoned order to be passed. ওই period গুলো bold হবে. Paragraph. It is made clear that this court has not gone into the merits of the contentions and rival contentions of the parties raised before this court. Full stop. The parties shall be at liberty to urge whatever points they wish to urge by relying upon the relevant law and rules.
And necessary documents also. So other like
Before the respondent number 3, by relying upon whatever records and documents they wish to rely upon. Full stop. Paragraph. If the reasoned order goes in favor of the petitioner, then the appropriate authority authorities shall give immediate effect thereto, positively within a period of 3 weeks from the date of the reasoned order to be communicated to such appropriate authority authorities. Full stop. Paragraph. Since affidavits are not called for, no, it's a report আছে তো
And the report, this is a formal affidavit আছে.
ওটা লেখা যাবে না
You say that you know report enter the merit of the case. No.
Report has been put.
Full stop. It is কি বললাম বল to be communicated. Paragraph. It is made clear that this court has that this order shall not create any right or equity in favor of the petitioner. If the petitioner is not eligible to receive his claim strictly in accordance with law. Paragraph.
Yes.
On the above terms, this writ petition WPA bold 1022 of 2022 stands disposed of, without any order as to costs. Paragraph. আচ্ছা ওই উপরে চলে যান তো after considering the
report has been filed.
অ্যাপিয়ারেন্স গুলোর উপরে নিচেই ঠিক অ্যাপিয়ারেন্স গুলোর নিচে পিটিশনারের কেসটা বললাম তারপর কি বলেছি হ্যাঁ
Since
হয়ে গেছে তারপরে একটা প্যারাগ্রাফ ছোট্ট ঢুকিয়ে দিন ফাঁক না থেকে যায় This court has also perused the report in the form of affidavit filed by the respondents affirmed on August 3, 2022. Thank you.
I come from a hearing matter. Yeah.
You're welcome. চটপট ডাকুন, চটপট ডাকুন। Yes, yes, yes.
Lord, in item 30, I appear for the petition.
Who's for the state?
Lord, Mr. Rahman, Mr. Moimur Rahman was appearing yesterday.
Where is he?
I don't see him in court today.
No, no. Yes, come. He repeatedly appears one after another. Maybe he doesn't like you.
Maybe he's not confident.
Passed over for the day. Next.
Lordship, I'm praying for not today.
Why?
Lord, I beg to appear on behalf of the respondent number 4, Lordship. But I have filed my affidavit in opposition, but no affidavit in reply has yet been received.
No affidavit in reply has been filed. You take extension, I don't mind. Ashur. You give all your appearances.
Yes, my lord. I've given the evidence for it.
Raja Shah. And who else? Who else? Say, state.
It would be better if you keep it tomorrow.
Why?
My senior.
No, there is no use.
Reply you have to file. Next. MS.
Mrinmoy Das.
Mrinmoy Das, Learned Counsel, appears for the petitioner. Paragraph. On the prayer of the Learned Counsel for the petitioner, time to file affidavit in reply stands extended till May 10, 2025. 4. Paragraph. After completion of the said period, the parties shall be at liberty to mention the writ petition for inclusion under the heading quote unquote for hearing before the next available circuit bench then. Next na kore before the available circuit bench then, comma, subject to its convenience, comma, upon notice to each other. Next.
Grateful.
Grateful, Lordship.
32.
I appear for the petitioner.
Mrs. Bose is appearing for the state, my lord. Due to a personal difficulty, she could not come, my lord. If the matter be placed before the next week, my lord, Monday.
No, Monday, then pass over for the day. Monday.
She's under some personal difficulty, my lord. She's not in.
Then
I cannot comment on a lawyer's personal difficulty,
no,
my lord.
that's all right.
Any day next week, any day next
My lord, I am having an urgency, my lord.
passed over for the day.
My lord, again. But she won't be coming this week, my lord. Any day next week.
Since an adjournment has been prayed for, give your name. Since an adjournment has been prayed for on the personal ground of
Vedasuti Bose. Vedasuti Bose. Appearing for the state.
MS Vedosruti Bose, Learned State Counsel, appearing in the matter, comma, the writ petition shall appear under the heading for hearing. এটা কিন্তু একদম নিচে চলে যাবে। On April 11, 2024. Next.
11 might be on a holiday.
My lord, the Eid might be
11.
Yes.
10.
Okay, grateful.
Keep your obligation.
Last. 33, my lord, I beg to appear for the petitioner. RTF factor বই আছে CRP.
Yes.
My lord,
three connected matter?
three, all three. Milord, 33, 34, 35, Milord, are more or less factually identical. Milord, here's one at length. Milord, the others I will just point out the factual differences.
Very well.
The question-
33.
33, yes.
Affidavits complete.
All complete, all pleadings complete. Milord, it will take a little bit of time. Milord, I will start, let me place the case, Milord, as far as I can. Milord, maybe I will take one more day to complete.
Then tomorrow we'll continue.
Yes, tomorrow. Tomorrow. That's better. When we keep forgetting.
No. If you start hearing today,
Yes.
continue tomorrow.
Tomorrow, yes.
I don't mind.
Yes. Milord, before Milord.
What is the matter about? Tell me in
Yes.
nutshell.
Yes, Milord, it's a matter connected with the service of a constable under the Railway Protection Force. Now, for a particular incident, Milord, a killing of a superior officer of the force, there were allegedly messages posted by certain persons.
Huh?
By certain persons of the force who had posted messages supporting the killing. Milord knows, Milord, there was in between.
Posted messages where?
On the social media, Facebook. Now, all those petitioners in 33, 34, 35, Milord, alleged to have posted comments on those postings, which the force construes as ratification and supporting of an act of killing. So, the allegation which was brought out against me was that I have supported and ratified an act of killing. Or, Milord,
Abetting.
Abetting on an act of aggression.
Any criminal proceeding initiated?
No, nothing. Now, Milord,
Who are you? You are.
I am a constable of the Railway Police
Oh,
Protection.
you are an
Force.
employee.
I am an employee.
A co-employee died.
A co-employee, a superior officer was
Whatever. A co-employee died.
Yes.
The incident
Milord would recall in a CRPF, it was widely circulated in
I don't
newspapers.
recall anything.
Milord,
I don't recall the names.
Milord, an officer of the force was killed by a constable in some other area, probably in Jammu Kashmir. That was widely publicized in the news. In social media, there were certain circulations regarding that. These three petitioners posted certain comments on those postings, which the force took differently, construing it as an act of ratification and support, which they eventually considered it as an act of indiscipline or whatever within the service rules. Now, Milord, subsequently,
No criminal proceeding?
No criminal proceeding against me. Now, a show cause was served. Pursuant to the show cause, an inquiry was conducted. A report was published. Immediately after the report, a second report was circulated, which modified the initial conclusions of the earlier report. Now, once the final order was passed, if we take the second report to the as the final order, which according to us, the second report ought not have been published at all in the first place. When the final order was passed, there was a period of appeal. In that period of appeal, I could not prefer the appeal before the appellate authority. I preferred an application seeking an extension of time so that I can prefer the appeal. That provision is there in the act itself. Instead of considering that prayer, the superior authority, the appellate authority himself, further preferred a show cause notice saying that the initial punishment that was with which I was saddled with, that is grossly inadequate. We propose to enhance the punishment. You submit your reply. Against that, we challenge before this honorable court. Justice Amrita Sinha heard the matter. Justice Sinha passed an order staying the subsequent show cause notice and asked the appellate authority to consider that prayer for extension of the period of appeal. Now, no decision was taken. Thereafter, 1 year, after 1 year, another show cause was slapped upon me, saying that they proposed to enhance the punishment or modify the final order. Now, after filing of in that context, this writ petition was preferred. Here we have challenged the entire proceeding, right from the show cause itself. During pendency of the instant writ petition,
a further penalty was promulgated by the appellate authority himself, saying termination of service. That has happened during pendency of the writ petition, which we have brought before this court by way of a supplementary affidavit. Now, this is, my lord, broadly the context. Now, according to us, after going through the final order, even the first authority himself says that my involvement in the entire incident is doubtful. Whether I have committed any act of indiscipline within the meaning of the RPF Act and the rules itself is doubtful. However, a token punishment was inflicted, but subsequently, on what basis this was changed to the extent
major
of
punishment.
Major punishment to the extent of termination of service. So this is, my lord, broadly the matter is all about.
And from this major punishment, you have not preferred any appeal.
No, I cannot, because this has happened during pendency of the writ petition.
Oh, how does it matter? Even if it has happened.
The appellate authority has passed. Now, I don't have a further second appeal within the act. So even that has to be considered by this court. Now, my lord has to take the entire circumstances in its entirety, whether it would be permissible in terms of the RPF.
I'm on a very really elementary issue. The one which is roaming through my mind.
Appellate authority.
Nothing. How far, on the basis of a comment posted in a social media, it's a media.
He, in quote unquote, he said, "Sahi kiya hai bhai ne." That was the comment he has posted.
Quoted in a social media. Mr. Moitra, you're there?
Majumdar.
So sorry, Mr. Majumdar, you're there?
Lordship.
My question is whether on the basis of a comment made in the social media, cognizance can be taken for criminal punishment, and at all any cognizance can be taken or not.
Right, my lord.
Let's say, let's not take it as a Facebook. Suppose tomorrow, these comments are made on a newspaper. Let's say Anandabajar, Telegraph, or whatever, a regular newspaper. What would be the effect?
Lord.
Then, so many people, their comment comes in the regular newspaper,
Right,
in so many ways. Can cognizance be taken?
Lordship, if I am permitted, my lord. First of all, my lord, let us differentiate between a criminal case and a disciplinary action. This is not a criminal case, was thrusted upon. It was
a separate thing.
Lordship, if a media comment can be directly connected to me, point the finger directly to me, I have to take the responsibility of such comment, wherever I post it. If it can be reasonably connected to the alleged maker of the comment, then the maker of the comment has to take the responsibility of that comment. I cannot.
To what extent?
To the full extent, my lord.
To?
Full extent.
Termination of a service.
My lord, now I come to there. My lord, we are dealing with a force. No insubordination, no indiscipline can be tolerated. If an assistant commander is murdered by the weapon used by the force in broad daylight during election duty by a member of the force, and some of the members of the force support that murder, is it not sufficient indiscipline, my lord? I ask myself. An assistant commander of RPF.
Question is, a media report, how far under the Evidence Act can be taken cognizance of?
My lord, this was maybe in the criminal court it would have been different, but the force has its own court. All the forces, armed forces of the Union have their own court.
Show me that media can be taken as cognizance.
Yes,
from your code. Read it out.
Lordship.
Just you read it out, sir, then I will read.
146(4) Railway Protection Force rules. The violation that he has been charged of. No member of the force shall act in any manner prejudicial to the discipline or conduct himself in such manner which is reasonably likely to bring discredit and reputation to the reputation of the court in any manner. That word is very, very large and elastic to take everything in its ambit.
Which means, which according to you, even if he makes a comment in a newspaper like this, same incident, same effect.
Lordship, most people will have a very certain, very stringent restrictions.
That's right, but
My lord,
which
first
shall
of all, if
which
I'm-
shall prevail?
My lord, if
Which
I'm-
one
if
shall
I'm
prevail?
permitted to being before Lordship, a force member will not be allowed to make any comment in the media.
Correct. If that is the rule, fine.
146 says you should not do anything that would be prejudicial to the moral and discipline of the
No, no, that's right, that's right, that's right.
Lordship, if we consider a media comment in the perspective of criminal trial, that takes a different color. But if we again take that same comment, bringing disrepute and discredit to the force, it takes totally a different color.
Show me the law.
Lordship, 146.
Facts are really very less.
Facts are less. Only 3-4 documents.
First, I must be satisfied with this.
Yes. That they at all have a cause of action to proceed against.
On the basis of a media comment, because Evidence Act does not recognize a media comment.
It's
That's
not
a-
even a media. Social media,
It's a media.
posted by someone else. I have
someone
commented
else.
on that.
That's right.
My lord, I
You have commented.
Yes, yes. that's right.
Sufficient enough.
That's right. That's right.
Sufficient enough.
Yes, correct.
Like if a death declaration, a dying declaration comes, that somebody, when I went there, somebody made this comment, then sufficient
Yes.
against that person.
Yes.
So
Now, so
your
far as
comment
social-
is sufficient.
so far
Question
as
is
let-
social media, because the Evidence Act is that no cognizance can be taken on a newspaper report.
Correct.
That's 88 Supreme Court, 89 Supreme Court, and lot more.
Correct.
Starts from Justice Hegde, Justice Chandrachud, the
Senior.
those are there. As I may be wrong in recollection.
And exactly,
but-
Millard, those are the angles on which a coordinate bench of this court has Millard quashed similar proceedings in another jurisdiction. I mean, in West Bengal, in another district. I have those judgments I'll place. And that's very
So
written.
you have to satisfy me on that first.
Lordship, then first, as I could read the mind of the court, I am to show my lord that how far Evidence Act is application, proper category in our inquiry and trial. My lord, let Mr. Ghosh finish. I have all the proceedings documents with me. I will one by one review how we went through the.
No, that's all. Let me accept your contention on fact.
Lordship.
I'm accepting, let's say, for argument's sake, I'm accepting for the time being that you have come to a reasonable conclusion. But on the basis of such conclusion, if you take a step which must have a legal sanctity, you may conclude something, sir, no difficulty. But while taking a penal step, then you must have a legal sanctity to take that step.
Now, my lord.
Satisfy me on that first, that
Right, my lord, that if I come to a conclusion that Mr. X is guilty of a violation or infraction of a certain statutory provision of the RPF rules, then the consequent punishment to that will follow. I am only to indicate to your lordship that X violated section L. For that, he is supposed to get punishment under section Z. Right. Lord.
So, vis-a-vis that media comment, how far can be taken into cognizance? Satisfy me on that first.
My lord has narrowed down.
Then further.
Right, no difficulty. So tomorrow, will it allow me to also to come back on this point? If I can also assess this court.
Case
Mr.
has not
Majumdar
been-
is shifting the burden on me
No, no,
to
my lord,
start.
he is the petitioner. Let him start. We are all here to find out the truth. na?
Right, right. Yes, absolutely.
How far? Because what he will do, his duty is to show that these are the events. Your duty is to show these are the chain of events. I don't mind, I don't disagree to that. Let's say for the time being. For the time being, I accept both of you on facts. Satisfy my mind on law. That how far media comment can be taken into cognizance.
In light of Rule 146,
Whatever.
which is the plenary provision for indiscipline.
Whatever, because when Evidence Act does not permit it, how far the service code, this is
Correct.
basically a service code,
Absolutely. Absolutely.
employment code.
Absolutely.
How far the service code can override Evidence Act? Can it be?
My lord, your lordship and my brother, Mr. Ghosh, will have now compelled me to burn a lot of midnight oil.
So, Millard, tomorrow it will retain its
Sir,
position in the hearing.
I don't mind. Let me be very candid. Ultimately, I cannot complete it.
It will
Then
be
where is-
completed. It will be a matter of Millard one. Millard,
I don't mind, I don't mind.
For me or Mr. Majumdar,
Fast over for the day, let it remain its position. I don't mind.
So efficient.
But this point, you also have to satisfy me
definitely
that this is not to be taken into cognizance in law.
Correct.
Now, if you satisfy me on that, and this will be mostly on precedence oriented.
Precedence.
So if you satisfy me on that, then the learned Deputy Solicitor General's work starts. How to demolish that.
Correct.
First, he has to satisfy me that these are not to be taken into cognizance. Then your task will start.
Lordship, he builds the ADP side as well.
Then your task will start.
Right, my lord?
And even today, I have to rise.
Yes.
What is gone is gone. Don't mention. But when the matter shall be called on. When the matter shall be called on. Ask your junior to be here. Even I allow virtually also. So not to worry. Not like this. It's an interesting point.
Very interesting. Very interesting.
How far newspaper media are not permitted to be taken into cognizance. And sir, you have to also place the law that the service code, basically this is the service code, will have a prevailing effect or supremacy over the Evidence Act.
But I was trying to indicate, my lord, is not supremacy, rather not applicable, non-applicable.
No, rather Evidence Act will not apply.
In that manner, as it applies in criminal trials. Because lordship, in every force act, my lord will find a typical section, as often I remember, section 80 of the Border Security Force Act, where there is an offense committed by a member of force, which is triable by the criminal court, like murder, like grievous injury, which can be tried by the normal criminal courts, but still the authorized officer, in that case it might be the DIG, will bring out an application under section 80, ask the magistrate to commit the accused and the entire case to him to be tried by the force court. So there are certain adjustment of jurisdiction, and that is also been notified by the Ministry of Home Affairs, that there is a adjustment of jurisdiction of criminal courts and the force courts. So keeping that in mind, my lord, we have to examine this one. It's interesting and a little bit tricky also, because these sections are not normally come across. Where the normal criminal courts under the
No, service code has its independent existence. No doubt about it. What you are saying,
No,
sir.
my lord, this particular section, when I first came across it, I got surprised. It is also jolted my senses that how come the normal criminal courts constituted under the criminal procedure code can be shut out. And it is true, my lord. It can be shut out totally.
But wherever it has been shut out, similar protections have been inbuilt in the service codes itself. So that the question of prejudice is always taken care of by the law.
That will
Be it by way of a general principle or by a specific provision.
All right, let's see.
That-
Let it remain its position. It
Yes.
will appear tomorrow.
Grateful.
আমি মিটিংটা করে আসি, তারপর সময় করে আপনি আসবেন, দেখিয়ে নেবেন। থ্যাংক ইউ, থ্যাংক ইউ।
স্যার সারা দিন